Yes.
Your Lordship, may I be permitted to mention? Your Lordship, yesterday my mentioning was allowed, however, service was not completed. I have annexed the notice as well, Your Lordship, may be included in the list. Your Lordship.
New motion.
No, Your Lordship, here in this.
Hearing I allowed yesterday all the matters.
Your Lordship, you have allowed, but I was directed to.
Hand over. Yes. Any other mention? I dismissed it.
No.
Hand over.
Lordship, motion matter, Lordship.
Liberty to mention, my lord.
I allowed all hearings yesterday, madam. Wait for Monday. Let us see. Wait for Monday. Mention on Monday. I'll take up.
May I mention, my lord?
Why didn't you not mention yesterday?
My lord. My lord, may I have you lordship's kind leave, my lord?
My lord, may I mention, my lord?
May I get your lordship kind leave to mention one matter, lordship?
Notice. Without notice, no mention. Yes, hand over. With no notice.
My lord, may I have you lordship's kind leave, my lord?
Yes.
One matter, my lord.
Yes,
My lord, may I have you lordship's kind leave?
My lord.
Any other mentioning? Yes.
My lord.
Hand over everything.
Lordship, may I get your lordship kind leave to mention one matter, lordship?
Withdraw. Do mention.
Lordship, may I get your lordship kind leave to mention one matter, lordship? Lordship, I am mentioning all.
My lord, may I have you lordship's kind indulgence, my lord?
Kindly wait. Because I have allowed the hearing matters, you have to wait. It will be called on. Yesterday, hearing matters were being heard. I was taking up hearing matters yesterday. Today also, likely, if time permits, I'll take up the hearing matters. Wait, let us see how it moves. Yes, sir. Which matter do you want to mention? Yes.
Lordship.
Content by? Shekhar Bisara. And দিয়ে দাও সামনে সপ্তাহে দাও আমাকে দেখিয়ে নেবে ফাইলটা নিয়ে yes what correction
instead of retirement of the petitioner the petitioner husband from the pension that is interest on getting.
You did not indicate that yesterday. Hand over. Yes, sir.
May I get your lordship kind leave to mention one matter, lordship?
Mentioning online, yes. Mentioning online.
Lordship, I am mentioning hearing matter, lordship. Lordship, this is a tender matter, lordship. This is the third round of litigation, lordship. First two rounds, they have cancelled my tender, lordship, that has been set aside. And this time, lordship, they have not only cancelled, they have cancelled the tender without any reason, lordship.
Why mentioning today, sir? Yesterday, I allowed so many mentioning.
Lordship, the problem is that, lordship, I tried to serve upon the state. State told me that their advocate has changed, so I have to hand over all the briefs to them, and thereafter I am mentioning, lordship. That is the problem.
Notice.
Lordship, my clerk is there, lordship.
Lordship, I am referring for respondent number 4.
Lordship, I have served, lordship. All, everybody.
Yes, sir.
Take it for me, I have served everybody.
Number yes.
Take it up
My lord,
Monday.
Small hearing matter.
It'll appear. Yes.
My lord, may I mention a hearing matter? My lord will kindly fix the matter on Monday with the batch of.
Madam, you hand over the slip or notice.
My lord, the notice has been served and the slip has been handed over. My fellow learned advocate is
very
there.
Very well. Any other mentioning?
My lord, may I mention?
My lord, may I my lord, one small hearing matter, my lord. My lord, I have served notice, my lord, upon the other side, the small matter with regard to interest on the dues, my lord, which has been paid, my lord, after 6 years, my lord.
Yes, hand over the slip. Okay, we
my lord, may I mention, my lord? My lord.
Yes.
My lord, this is WPA 642 of 2024. Praying for the inclusion of this matter in the list on Monday under the heading new motion, my lord.
New motion, hand over the slip.
Yes, my lord. Wait for
yes. Yes.
Lordship, at the time.
এই পাহাড়ে এটাকে বন্ধ করো না ঠান্ডা লেগে যাবে তখন বন্ধ করো yes what is the interim order
Lordship extend, it was stayed by Lord, Justice.
When is the
Gaurav.
interim order expiring? Who is appearing on the other side?
Lordship, it is expiring tomorrow.
Has affidavit in opposition been filed?
Lordship?
Affidavit in opposition been filed?
No, Lordship. No, Lordship.
Can I file affidavit in opposition? থাকলে কেন থাকবে তো?
Yes.
Mr. Shaha, have you filed affidavit in opposition?
Lordship, we have some stuff.
I'm not in position in application.
This matter has come up under the heading extension of interim order. দেখুন। No, heading not. This is an application. Why have you filed an application?
For the interim extension, Lordship.
Interim, the order has expired.
Yes, Lordship, it will expire tomorrow.
The matter has come up under the heading extension of interim order. Full stop.
Lordship,
It appears,
till the disposal of the.
it appears that by order dated 13th of March 2024, this court was inter alia pleased to, a coordinate bench of this court was inter alia pleased to grant an interim order which is valid till interim order thereby staying the operation of the impugned order dated 30th May 2023 passed by the respondent number 2 for a period of 6 weeks. 30th May 20, for a 6 weeks. 6 weeks হচ্ছে 13/3. 13/3, 13. Madam, it has already expired. It was still,
Copy of the.
it was still 23rd.
Lordship, we have already filed the application on 18/4/2024.
Serve a copy.
No copy has been served.
Serve the,
State is not a party.
Accident Labor Commission, we are.
Lordship, our contention is towards, against respondent number 2.
so state is a party. Is state a party?
Accident Labor Commission, we are.
You will not serve.
Lordship, copy of this one.
You have served on everyone. Dekhi affidavit of service.
On the state, nothing has been served.
State not necessary. Assistant Labor Commissioner has to be served. Let us see.
But GP is not. That we can change the state.
GP is not necessary. Assistant Labor Commissioner. If assistant, all have been served. Affidavit of service filed in court. Today is taken on record. Full stop. Despite service, none appears on behalf of you are appearing for which party?
We are out of the state.
State is not independently a party.
Accident Labor Commission is the part.
So you are appearing for Assistant Labor Commissioner. None appears on behalf of the respondents.
Usually we appear.
On behalf of the respondents, 7 on behalf of the respondent numbers 2 to 5. Though Mr. Shaha, learned advocate, and appears on behalf of the respondent number 1. No, though Mr. Shaha, learned advocate, representing the respondent number 1 is present in court. Give him a copy. Give him a copy.
My lord, as he is appearing, we will serve the copy with
Very
very
good.
short.
Very good. ওপরে প্রথমে কি বলে this is an application for
Let it be recorded that the copy to be served.
We always serve the copy within very short time.
by an order dated 13 March 2024, a coordinate bench of this court was inter alia pleased to thereby staying the operation 30th May 2023 passed by the respondent number 2 for a period of 6 weeks. Full stop. It appears that the application for interim order has been taken out on 18th of April 2024. Full stop. The same, however, could not be taken up for consideration before this court. No, same, however, 30th April, 18th of April 2024 and has been pending since then. Full stop. Having regard to the aforesaid, I am of the view that the interim order passed on 13th May, 13th of having regard to the aforesaid, and taking into consideration the submissions made on behalf of the parties and the materials on record, I am of the view that the interim order passed on 13th of April 2024, which was valid till 13th. Act, Dewey, valid till 24th of April 2024, be reimposed and reimposed, full stop. The same shall continue. The same shall continue till the end of July 2023, full stop. Say end of July 2023, full stop. Since July 2023, full stop. Since it does not appear from the records that any affidavit in opposition has been filed on behalf of the respondents, the time to file the affidavit in opposition by the respondents is extended. Time to file affidavit in opposition in terms of the order dated 13 March 2024 is extended by a further period of 2 weeks from date. Further period of 3 weeks from date. 3 weeks from date. Reply, if any, there to be filed within 2 weeks thereafter. Or on the reopening of the court, whichever is later.
Extend this interim order till the disposal of.
No, sorry, madam. 3-2 কত বললাম তাহলে 3 সপ্তাহ হলে কত হচ্ছে আজকে থেকে 3 সপ্তাহ ছুটি পড়ে যাচ্ছে তো হ্যাঁ 2 weeks করুন আজ থেকে 2 weeks 1 week. List this matter before the circuit bench. Then list this matter immediately after the expiry of the period for exchange of affidavits before the next available circuit bench.
Serve all the copies.
Can dispose of.
Lordship, in item number, Mr.
ওই যে
Radhesha will
connected
appear.
application being can 1 করবে না নাম্বার দিয়ে দেন
Lordship,
Lord,
in
I
item
get to
number
appear
two-
for the respondent number 5, Lordship. Lord, I am opposing the prayer for any extension of interim order since, Lord, no copy, neither the writ petition nor the Lord application has ever been served upon us.
দেখি ফাইল দেখি who are
Lord,
you
Lord, I am the respondent number 5. I am the owner of a house. I am a senior citizen. In my house, they are nobody. Lord, they are capturing a portion of my house and they are sitting tight over there.
have you filed a vacating application
No, and I
have you
neither
filed
have
a
any.
vacating application please answer
Lordship,
the
I could
question.
not, since I don't have the.
Why
No,
are you
Lordship.
appearing today? How did you come to learn that this matter is appearing in the list? You have not been served with
But
the
I
copy
went
of
to
the
the
application.
SDO. I'm submitting.
Yes.
Your Lordship, can you allow me? But I went to the SDO for execution of his order. He
Yes.
said that a writ application has been filed and ex parte interim order has been passed. My Lord.
When did you come to learn?
But am I not
When did you
entitled?
come to learn?
No, in the last week.
Last
Lordship.
week. Did you write a letter to the petitioner asking for a copy of the application?
No, Lordship.
Sir, before making an objection, go through the facts. Yes. Where is the affidavit of service?
The first affidavit of service. This is the first affidavit of
Holding in your hand.
Yes, no.
It is in your pocket.
No. This is the first affidavit of service. And the second extension of service of extension of application, Lordship, this is the service.
Oh.
So this is an order passed.
Why did you not comply with the deed?
This is the first.
When did you serve? Immediately order was passed on 27th March.
This is the affidavit of service. Can you see? I've served. the
You
copy.
tell me, when did you serve?
Lordship,
On the private respondent?
prior to filing of the writ petition.
prior to filing of the petition, I served
No,
copy.
no.
Even post
Sorry.
passing of the order.
Sorry, sir. Paragraph 1, read the order. Kindly read the order,
No,
paragraph 1.
Kindly see.
Yes.
Because at that point of time, evidence was not ready. That's why I kindly see the evidence of service. I served it. Prior to filing of the petition, number 1. Number 2, even passing of the order, I immediately served the.
Where is that? Where is that? Where is that service? Where is the service?
Evidence of service is there. That's kindly see.
Sir, kindly show me from the affidavit of service. Where is the,
I'm sorry.
yes. Where is the service on the respondents?
I'm sorry.
Lordship, I would like to submit
Is
one
there is-
more thing.
Sir, that is the original copy, sir. Affirm copy.
Sorry.
It's an affirm copy, sir.
Sorry.
You are an advocate, sir. You cannot
Sorry,
take this
sorry.
liberty to mark on an affirm copy. We do not mark on an affirm copy by the pen.
Only to Lordship.
No, not for this purpose. You must be aware. This is an affirm copy.
Should be. I stand corrected, Lordship. Should be. It should be. I stand corrected, Lordship.
You cannot have the liberty to correct a document which has been affirmed.
Sorry.
I cannot take notice of this document now. It has to be reaffirmed.
So only I'm just showing Lordship.
You should be aware of the situation.
Absolutely. My
You are an advocate, sir. How can you mark on an affirmed copy like this?
only to show your Lordship.
No, you cannot. This is an affirmed copy.
Sorry. My mistake. Sorry. The respondent number 5 is the here, the Shakti Pada Ghosh, Lordship. And you see, Lordship, I have served it prior in time. The matter was heard out.
This is on 22nd of March.
Yes. And the matter.
Where is after the order? Where have you served?
Yes. Then
After the order.
kindly take out text of my application, extension application
Yes.
at page. At page 15 of my application. Again, after passing of the order, I served it. At the same address. They didn't take any step.
I did not receive any copy, Lordship.
What is the interim order?
Interim order is also 4 weeks stay upon the impugned order of eviction. At paragraph number 6 of the relevant order. At page 13.
Do you want to file any affidavit? Mr. Shah?
Lord, I will certainly, Lord, but before that, Lord, the extension.
I've seen the affidavit. I've seen service on you is complete. I've seen that.
Lord, may I, with your Lordship's kind permission, may I have a copy of this, Lord, affidavit of service? Lord, I shall.
You have to come to court for that purpose. I cannot send you online.
My junior is there.
Mr. Raja Shah.
Yes.
This regard, Lordship.
You ought to have been here, Mr. Shah. Madam, it is served. Find out. Hand over a copy.
I'm grateful, Lordship. Lord, if your Lordship kindly allow me to say.
Wait, what is your defense today? Do you want to file affidavit? You want to file?
I will. Against the extension of interim order, Lord, the application.
No, sorry, extension of interim order, I will not permit you to file affidavit.
Lord, may I be kindly permitted to, Lord?
If you want to file the affidavit to the main matter, you are at liberty.
But before that,
I will not keep extension of interim order pending, Mr. Shah.
Lord, before that,
Application for interim order pending.
Lord, Lord, before that, if your lordship.
Yes,
kindly allow me.
madam, received it?
Lordship, actually, it
Yeah,
is,
all has been sent. See the previous affidavit of
Lordship,
service
see-
also.
mail, Lordship, I don't know
Yes.
whether mail has sent, they have received the mail or not. Maybe there may be a technical issue.
Maybe.
So.
So
we
you
are-
were aware, madam, you were aware of the situation. You ought to have written a letter. You ought to have
Yes,
written a letter. You want to file an affidavit, Mr. Shah?
But I will certainly, Lord, before
Yes.
that, if your lordship can allow me to say about, Lord, before the extension, lordship. Lord, I need to say something on merit.
You did not file an application for vacating even after being aware.
My, I
Mr.
did
Shah,
not,
you know all this, Mr. Shah.
Lord, I did not have
No,
the
no,
copy
no,
of
no,
the
no,
writ
this I
application,
will-
my lord.
No,
But I
file
was
an,
not aware of the cost.
file an application for vacating. File an application for vacating, Mr. Shah.
I will
Take out,
certainly.
take out an application. Well, the court will consider immediately. Take out an
But
application.
before that, there is a point of law, my lord. If you
No,
lordship
no,
kindly
no,
allow.
not-
My lord, the order impugn, my lord. The
Having
order
not filed an application, I will not permit you to argue on this.
My lord, kindly take it up in the next week, any day, lordship.
Yes,
I shall
yes.
come
Yeah,
with
yeah,
you.
file an application. I'll tell. Every day I'm taking out application.
I'm grateful, lordship. Lord, kindly fix it on Thursday, lordship.
Not
In the
fixing. You come up with your application, I will hear you. Come up with your application. 1-page application, I will hear you. The present application has been filed because the interim order is expiring when? Tomorrow. So I can't keep it pending. Yeah. The present application being Can 1 of 2024 has been filed interiorly praying for extension of interim order. Post of Mr. Shah, learned advocate representing the respondent number 5, vehemently opposes the extension. Post of he submits that the petitioner has not served a copy of the his submission I will not record. He submits that the copy of the he submits that copy of the writ application. He submits that copy of the writ application, including the application for extension, has not been served. Post of served. Post of. From the records, however, and the affidavit of service filed in court, including the annexure to the present application, it appears that it prima facie appears that service has been effected. Service has been effected on the respondent number 5. So Miss Bose, learned advocate, assisting Mr. Shah, who is present in court, could not deny the factum of no, you are denying. He is denying. So there
Let a copy be supplied to us.
There might be
already
technical
supplied. Does not challenge the email ID. Does not challenge questioner. Does not challenge the email ID of the respondent number 5.
Lordship,
As
written that-
appearing at page number 15. 15. Yes. Page number 15 of the said application.
But I need to check from my client whether at all it is his email
Yes.
ID.
And you are not in a position to controvert it today.
Lordship,
You file an application. You file an
I will.
application.
I will certainly.
You, Mr.
I will
Shah, you
certainly.
cannot have personal knowledge.
Lordship.
The client has to come up with an application.
Lordship.
I find, although this order has been passed, no, I find that this order has first of all, it however appears, according to Mr. Shah, the respondent number 5 had come to learn with regard to the factum of passing of the order dated 27th March 2024 only in the last week from the office of the
Well, subdivision officer.
from the office of the subdivisional
Officer.
from the office of the respondent number 3 from the office of the respondent number 3. Full stop. Full stop. I however find that no application for vacating has been filed. The interim order is valid till tomorrow.
27th.
The interim order is valid. The interim order valid and subsisting. The interim order is valid and or subsisting. The interim order is subsisting and or is valid till tomorrow. The interim order is subsisting and or is valid till tomorrow. Having regard to the aforesaid, I am of the view that the interim order passed on 27th of March 2024 should be extended.
But kindly for a shorter period of time.
Let the same be extended, should be extended. Accordingly, The interim order passed on accordingly, the same is extended till the end of June 2024 or until further orders, whichever is earlier. Full stop. Full stop. Let affidavit in opposition to the present application as prayed for.
But kindly do not pass right at this moment, otherwise my vacating application will be diluted.
Then I will record that. No, then I will record that you are not interested to file affidavit opposition.
No, kindly do not record that.
Affidavit,
Otherwise, my
okay, I am
vacating-
taking up the matter. So you can always file. Let affidavit
My
in opposition
vacating
to
will
the
be
present
diluted,
application be filed within a period of within.
Any shortest possible time.
You tell me. You will
2
file
weeks. 2 weeks. 2 weeks. Sir.
within a period of 2 weeks from date. Reply if any there to be filed within a week thereafter. Place this matter before the next available circuit bench immediately after the expiry of the period for exchange of affidavits. Next.
Let a copy of the affidavit of service be handed over to my.
Hand it over to your junior. Hand it over to your junior.
Lordship, I just only state
Get
one.
it from him. Get
Yes,
from the
Lordship.
record, madam. You are my officer. You are entitled to go through the record. Can is disposed of. Can is disposed of.
Grateful, Lordship.
Yes.
Grateful, Lordship.
All the next matter. Yes.
Lordship, Mr. Vinay Saraf is appearing virtually.
Yes.
Appearing for the petitioner, my lord.
Yes.
I heard the respondent.
Yes.
My lord, I appear for the petitioner virtually, my lord.
Yes. I hand over.
Am I audible, your lordship?
Yes, you are audible. Yes, Mr. Sharaf, continue.
My lord, I thought your lordship has not got the file.
No, I have heard you.
My lord, the issue in this petition is, my lord, that this is a matter wherein an order has been passed under the service tax law imposing a service tax of 5,71,35 lakh 583 rupees with equivalent amount of penalty and interest. But the issue is that under the service tax regime, there was a mega exemption notification.
There was a
exemption notification, my lord. Mega exemption notification.
Mega exemption notification.
MEGA, mega.
Yeah, I get you. Yes.
Mega exemption notification, in terms of which, my lord, I was entitled to exemption on services provided to the government and government entities, whether it is state government or central government, if the work is relating to the irrigation and the work done for railways. So, my lord, in my case, my lord, I provided services to the railways, various types of works, my lord. All the works orders, my lord, were annexed in reply to the so-called notice which was issued to me. My lord, but the order has been passed without considering the documents on record by stating
Where is the order? Where is the order? Which page?
But before, my lord, I take your lordship to the documents, my lord. Let me submit, my lord, the point of law which I wish to urge, my lord. Just give me 2 minutes, my lord.
Yes.
My lord, so, my lord, that the order is non-speaking. That is point number 1. Secondly, my lord, the so-called notice itself, which has been issued, is outside the period of limitation. Therefore, my lord, the entire exercise is without jurisdiction.
Why did you not
Thirdly,
challenge immediately on the issuance of the show cause? Why did you not challenge this?
My lord, it is a, my lord, that point was raised, but it was not considered. That point of limitation was raised in my reply.
Mr. Shara, I'm not on that. I'm asking you, when was that show cause notice issued?
But that show cause notice was issued on 28/4/2021.
Yes. And when it was issued, why did you not challenge it before this court? As without jurisdiction?
That was not, my lord, because I wanted to avail my remedy before the authority itself, my lord, that if he considers, my lord, because on merit itself, my case was that I am exempted. So both the point of limitation as well as on merit I raised before the concerned authority. My lord, he did not consider any of those points. And thirdly, my lord,
which page is the show cause?
My lord, one more point, my lord. Just, my lord, I am briefing the, my lord, the proposition of law which I wish to raise. My lord, thirdly, my lord, that prior to the issue of so-called notice, there is a circular of the department itself which says that if the demand exceeds 50 lakh, then there must be a pre-so-called notice consultation. My lord, it is a kind of mediation exercise to avoid litigation. That prior to the issuance of so-called notice, there must be a pre-SCN consultation. So that was also not done. So, my lord, on this primary proposition of law, I am arguing this matter, my lord. Now I take your lordship to the so-called notice. And fourthly, my lord, the so-called notice is issued the order which is passed is beyond the scope of the so cause notice. So, my lord, there are a number of judgments of Supreme Court which says that the order has to restrict itself to the cause mentioned in the so cause notice. The order cannot be passed on a ground which is not mentioned in the so cause notice. There cannot be any, my lord, improvement of the order, my lord, by way of a beyond the scope of the so cause notice. So these are the, my lord, the main point of law which I wish to urge.
Very
Well,
well.
now I take
I will hear you. I will hear you. I only
ma'am.
want to know at this stage two things. Where is, first of all, where is the show cause notice? First,
But the so cause notice is on page 52.
page 52. First page 52. Then show me where is your response.
My lord, my reply is from page 58 to page 130. Page 58. 58.
Oh, 58 to 130. Very well. Now, where is the demand thereafter? Final order?
My lord, the final order is on page 137 to 153.
1 minute. 1 minute. 37. What is that page 131?
137, my lord.
What is that? What is that page 131?
131.
Fixation of personal hearing. Okay, so you are given personal hearing. Okay.
Yes, my lord.
Very well. Then 133 is record of personal hearing. Very well.
Yes, my lord.
Then is 137 is the final order. Okay, fine. Fair enough.
Yes, my lord.
Forwarding adjudication. This adjudication is under section.
This adjudication is under section 73, my lord, of the Finance Act 1994. My lord, with respect to service tax, my lord, there was no law ever formulated. The service tax started from 1994, but it remained within the Finance Act.
So
So
this
the Finance
was
Act-
Finance Act. This was under the Finance
Finance Act.
at that stage.
Yes, my lord.
And under the Finance Act. Fair enough.
Yes, my lord.
Okay. So this is the final order. Now, is
Yes,
there
ma'am.
any appellate provision?
Yes, my lord, there is a provision for appeal.
Provision for appeal to challenge the final order.
Challenging the final order.
Have you availed that?
No, my lord. I have come to the court, my lord.
This is passed on 13th of April 2023. Why have
Yes,
you
ma'am.
not challenged the final order before the appellate authority? You have to deposit any amount. Are you
My
required?
lord, I am required to deposit 7.5%. 10% rather, sorry.
10%.
10%. 10% of
The disputed service tax amount, which is 5 crore 71 35 lakhs 583.
very well. So your point of law is A, that the final adjudication is not confined to the show cause notice issued. B, that
Yes.
you were granted an exemption and they did not consider this
Yes.
exemption. And the three, the most vital
Yes.
and the important point, it is beyond the period of limitation.
Beyond the limitation. So, my lord, that is beyond jurisdiction. And on
Correct.
this point, we have a judgment of this Honorable High Court that if
Arre,
the
wait,
issue
sir,
of jurisdiction is raised. Yes, my lord. Yes.
Wait, I'm not so fast as you are. You
No,
are-
I'm sorry, my lord. I'm
Yes.
sorry.
So your third point is on limitation. Now show me what is the
Yes.
limitation. Show me what is the limitation.
My lord, my junior is there. He will hand over a compilation to you, which incorporates all the judgment which I wish to
No, I
rely
don't need
upon
to
and
see all the
relevant
judgments.
provision.
You show me the limitation from the
So, my
statute.
lord, the relevant provision also, my lord, relevant provision is also there. All the, my lord, the section and the notification, circular, everything.
Dekhao. Mr. Sharaf wants to argue the entire matter for the whole day.
It is a motion stage.
Yes. Yes, don't show me the judgment, show me the statute. Show me the statute.
My lord, section 73, my lord, it starts from page 45.
45. Directly on the point of limitation.
Yes, my lord. My lord, I am reading out. I have to read out section 73.
Yes.
Where any service tax has not been levied or paid, or has been short levied or short paid or invoicely refunded, the central excise officer may within 30 months, but the 30 months from the relevant date, serve notice on the person chargeable
What is
with
the
service
relevant date?
tax.
What is the
which has
relevant
been-
date? What is the relevant?
Relevant date, my lord, the relevant date is in, my lord, kindly go to page 47. Kindly go to page 47.
Yes.
Relevant date is defined over there.
Just a minute.
My lord, Roman 6. Sorry, 6. Well, it's subsection 6. For the purpose of this section, relevant date means in case of taxable service, in respect of which service tax has not been levied or paid or has been short levied or short paid, where under the rules made under this chapter, a periodical return showing particulars of service tax paid.
So
during the
return is
period-
filed.
The
In
return
your
was not
case-
filed.
So in your case, no return was filed.
No.
Yes.
And then, my lord, I am covered under B, where no periodical return as aforesaid is filed. The last date on which such return is to be filed under the said rules.
What is the last date?
My lord, that is specified in Rule 7, my lord, which is on page 54.
Rule 7. Rule 7.
Page 54, Rule 7, my lord.
Yes.
Kindly refer to sub-rule 2, my lord. But every SSE shall submit the half-yearly return by 25th of the month following the particular half year. But this is the, my lord, so
Just a minute, just a minute. Every SSC shall submit half-yearly return by 25th of the month following the particular half year.
correct, my lord.
Means it's July, 25th of July.
No, half is the financial is starts
I
from
see.
April, my lord.
September. 30th
September.
of September, so 30th of 25th of October.
So 25th of October.
Correct. Now, if that is so, when was the show cause notice issued?
My lord, the show cause notice was issued on 13th April 2021. My lord, kindly refer to,
In respect of?
sorry, 28th of April 2021, page
I've got
50.
it. Yes, in respect of?
For the period 16-17, my lord.
16, 17. So it is
Correct.
beyond the time.
Beyond the time limit of 30 months.
Fair enough.
Number P4.
Yes, sir.
My lord, the due date expires on, my lord, for the September 15, the due date is 25th of October 15, and the 30 months expires on 25th of April 2018. 25th of April 2018. And for March 16, the due date for filing of the return was 25th of April 2015. And the 30-month period expires on 25th of April 2018. 25th of October 2018.
30 months expires on?
For March 16, 25th of October 2018.
Fair enough. That is all?
So,
Yes, sir.
on the limitation, but my lord, section
You cannot
73.
succeed on the limitation. If you cannot succeed on the limitation, rest I will not consider, Mr. Sharaf. For the time, if you cannot succeed on limitation, rest I am not going to consider. I will send you to appellate authority. Let me find out from the other side.
My lord, kindly, there are judgments of this Honorable High Court, other High
And
Courts
not
also
necessary
on
for the
limitation.
judgments. Let me hear from the other side. I have not
Yes,
questioned your action or your submissions. I have accepted you on face value to that extent. I am sure that you
Yes,
would not mislead the court. That is the reason I have accepted you on face value. Why will you say
Yes, ma'am.
something which is irregular and incorrect? So you are backed up by
Yes,
authorities, I am aware. Let me hear from the other side. Now you show me before
ma'am.
that, where is your response to this? And this point has been taken by you.
That is starts from page 58.
Yes, only relevant point, relevant point. Point of limitation has been taken by you.
1 second.
Don't say in terms of section 3 of the Limitation Act, it is not required to be taken. Wait, other side is still
My
petition.
lord, kindly refer to page 60.
Yes. Yes.
my lord, it starts from second sentence. For that, the suppression of fact with intent to duty cannot be inferred, and the demand is hopelessly barred by limitation. Since suppression of fact with intent to evade duty cannot be inferred, and the demand is hopelessly barred by limitation. In support of the extended period of limitation, notice rely upon judgment of so and so, wherein it has been decided by the apex court that when the department
Very well. Rely on one judgment, best judgment you have. Mr. Sharaf, one judgment. In support of this limitation, one judgment. Anyone which you consider the best.
Yes, my lord. On the point of limitation, we have a judgment of our own High Court, my lord.
Yes, yes. Show me that.
One second, my lord. Kindly just give me
Yes,
one
yes.
moment. Kindly refer to page 147, my lord.
Yes.
Compilation.
Kindly refer to page 149.
Just a minute.
What the 140? Will not read petition.
149 of the
149, paragraph
compilation.
11.
Mr. Boning, 149 of the compilation. This is a judgment by the Honorable Chief Justice. Delivered by the... Yes, which paragraph?
Paragraph 11, my lord. Paragraph 11. My lord, shall I read out, my lord?
No, I'll go through. Now, there is a provision for invoking extended period of limitation, Mr. Sharaf.
In extended period is there.
Where is that?
I did not read. I was
No,
in
no,
section
it's not
73. It's
I see, I see.
your lordship queried me about the relevant date. That
It
is where
is
my
all
lord, we
right.
changed
All
to
right.
sir.
That is all. Yes, Mr. Bonik.
Yes. My lord, first of all, my humble submission is that
You have to file affidavit, Mr.
kindly
Bonik.
have a look into the
Mr. Bonik, you have to file affidavit. Don't
right,
you?
Right. There are some facts and issue also. I think so.
Only
Moreover,
it is not a matter of question of challenge on law. It's also a question of factual challenge. Certainly.
factual challenge.
But he has an appellate provision.
Appellate provision.
Very well,
That
very
is
well.
why
So
I'm-
what appellate provision? What is the extent? 10% is the extent
10%
of
of the disputed amount.
this. What is the disputed amount?
5 crore something.
5 crore something. I'll direct him to secure 5 crore something.
Yeah.
Not secure. Pay you 5 crore something. You pay him. Mr. Sharaf.
But about that, my lord, Mr. Himanshu, my junior is there who is dealing with the client. So,
No, I'll direct you to pay. And this is direction. I'll direct you to pay, and I will hear the matter on finally on affidavits. I'll grant you stay to that extent. Matter has to be heard.
yes, my
But
lord.
without paying this, I don't think it is not. Then I will not entertain the
How
matter.
much your lordship? How much your
10%.
lordship is going?
10%.
Huh, my lord?
10%.
My lord, 10% will be too harsh,
No,
my lord. Too
no,
harsh
no.
upon.
No,
My
no.
lord, but it is-
5
it is-
crores,
it is also-
10% is how much?
5 crore 10.
50 lakhs, my lord. My lord, it is
How much?
contractor, my
50
lord.
lakh.
My lord, kindly appreciate. My lord, kindly
5
appreciate.
crore is tax, my lord. 5 crore is tax.
I asked you what is the disputed amount, Mr.
Disputed
Moni.
amount is 5 crore. And
If that is disputed amount, he will pay disputed amount 5 crores,
Yes,
10%.
yes.
What is the provision of the appeal? Show me.
Provision of the appeal 35.
My lord, the provision.
Central exchange like 35 ta bar karo.
Now, if ultimately one thing I want to know, if he succeeds in the writ application, what will happen to this money?
It will be refunded
With interest.
to the assessee or
With
to the
interest.
petitioner.
I'll provide for that.
Yes, yes.
What is the interest? You will pay refund?
1%
per month?
6.5 something like that.
Not 1% per
No,
month.
my lord, it is
Final
6%.
6%.
6% annually, my lord. It is 6%
Annually.
Annual. That is the government rate.
Where this petition will be decided prior thereto. I am
My
direct
lord, 10%.
My lord, my
provision.
one submission is that in
No, appellate
adjudication
provision.
order.
Mr. Monik, I cannot decide this
10%.
now.
It is
Had it been
mentioned.
the principal bench, I would have heard the matter much longer. But it is not possible. There are so many matters which are waiting here. So, Mr. Bonik, answer me on this and tell me, Mr. Bonik, what is the provision for appeal?
Provision for appeal.
My lord, it is section,
Subclause
my lord,
one.
it is section
86 subclause 1 of Finance Act.
86.1.
Finance Act of Belgaum.
Which page, Mr. Sharaf, which page?
my lord, that provision for appeals relevant section, my lord, I am not annexed to the political lordship, my lord.
Hey, no. Finance Act, no. Ano, Finance Act, no.
In the adjudication order, my lord.
No,
it is
Service
mentioned-
Tax Act, why are you showing? Finance Act, you have to show me.
No,
Substance is Finance Act 1994.
Yeah. Dekho.
86
Yes.
subclause 1
86 subclause 1.
of the Finance Act 1994.
Where is the provision for deposit of disputed amount? Where is the provision for deposit of the
My
disputed
lord,
amount?
it is there in section 35 of the
Excise. Central excise. It is
section 35F,
Of the?
Central Excise Act.
Yes, copy.
Section 35 of the Central Excise Act.
They get a copy. You copy. Is it in the compilation? Yes,
No,
sir.
my lord, it is not there in the compilation.
Acha,
Section
ठीक है।
35F is not there.
Are Central Excise Act now? I am entertaining this matter on the question because he has made out some grounds. Okay. He may succeed, he may not succeed. But I'll put him to terms.
all the grounds, my lord, all the grounds they could have ventilate before the appellate authority also.
No, because
Without-
today if it is found out, you see, Mr. Boni, prima facie, apparently if it is clear that this so-called notice is beyond jurisdiction.
No. It is
No,
not
beyond the
jurisdiction.
period of limitation.
No,
Beyond
no.
you can then entire matter goes. Therefore, I understand, Mr. Bonik, for that, I have to consider this. And independently, I cannot hear out his case. There are other points which he has, for
Yes.
which you need to issue an affidavit.
All right.
It is not that his writ application can be thrown away. He is not maintainable at all. He may have an arguable case, considering the nature of challenge made in the petition. So it would be prudent at this stage to admit the petition subject and put him to terms.
All right.
You
My
are
lord,
not
it is,
at a
my
loss.
lord,
You are not at a loss. Revenue is being secured. Object of the, what is the object? Revenue. Yes. Then,
my lord, may I?
and if he succeeds, it'll be, and I'll put it to, this application will be heard on expeditious basis that you will be, either you put in the opposition. If you do not put in opposition, without the opposition, it will be heard. Then you have nothing to say. I will record that these are peremptory directions. Yes.
My lord, may I
Mr.
correct
Shah.
myself? My lord, the pre-deposit is 7.5% of the disputed amount.
Whichever is the amount, I will provide for that. That is why I'm asking you provision.
17, my lord, section 35 capital F of the Central Excise Act.
Yes.
May I read out, my lord?
Check up. Section 35 of the
35 capital F for father, my lord.
just
Central Excise Act.
deposit.
Shall I read out, my lord?
No, yeah, I'll find out. F.
35 capital F, my lord.
Yes. Capital F, II. 7.5.
Capital F, my lord,
So
Roman
it is
2,
not
my
even,
lord. I will be covered
not
under
even
Roman
50
2.
lakhs. Mr. Sharaf, it is not even
Yes, my lord.
50 lakhs.
No, my lord, Roman 2 is 7.5% of the disputed,
So it
not
is
my lord
not even
10%.
50
Roman,
lakhs. So it does not even work out to 50 lakhs.
no, my lord,
Less
kindly,
than
my
that.
lord, kindly appreciate. My lord, I just give me 1 minute, my lord.
Yes,
My
yes.
lord, my lord, service tax is an indirect tax. Unlike Income Tax Act, where somebody who earns the money, he pays it out of his pocket. Whereas the service tax, the service provider is entitled to receive it from the service receiver. So in this case, the government was the service receiver. My lord, had I been taxable,
I have to call
would-
for affidavits, Mr. Sharaf. Without affidavit,
my lord,
if you
my
can
lord,
say,
just give me,
if you can say that I can decide this matter without calling for affidavits, then I can hear you fully.
my lord, that also
Copy
can
that.
be done. Why, my lord? My lord, I
Because,
refer to one judgment. My lord, one judgment of the Honorable Supreme Court, very recent judgment. The Honorable Supreme Court has said that if everything can be culled out from the available record, then it cannot be improved by
Correct.
the affidavit.
So the
My
records
lord,
have to be called
if
for.
whatever is the order,
So the records have to, I'll call for the records. I'll not grant any stay in that case.
no, my
I'll
lord, the
call for the
record is there
records.
in my
Let the records
petition.
come.
My
No,
lord,
they have to
my
consult the records. I have to give them time. You have come and moved the matter. Mr. Sharaf, we understand this. I have to give them time. So then I'm not granting any stay. I'm just here. I will hear
No,
out
my
your
lord.
application.
No,
No
my
stay
lord,
is
what I'm
necessary.
submitting is, my lord, what I'm submitting is that all the documents have annexed to the petition.
Wait, sir. Why are you? If you go on showing
My lord,
further,
I have annexed.
that will not improve the position, sir. Mr. Sharaf, I understand you have relied on all the documents in the petition, but the
Yes, madam.
respondent should be given an opportunity to find out whatever is there, correct or not. So this
Yes, madam, then
opportunity I have, I'll
kindly give
place it in
direction
the
for
next circuit. I'll say that matter shall be heard. I'll place it in the next circuit. Then I
no,
will
my
not
lord,
grant any
kindly
stay.
no, my lord, kindly give direction for affidavit. I do not have any
Yes.
problem.
Then if
My
I
only
have grant
humble,
application for affidavits, then I'll grant stay subject to putting in this amount. I'm making it very clear. Because had it been the principal bench, Mr. Sharaf, it would have been a different situation altogether.
yes,
Here it is
my lord.
different.
Yes, my lord. Just give me 1 minute, my lord. One minute, my lord. Give me, my lord. Then pass whatever direction your lordship deem appropriate, my lord. Just 1 minute. Just 1 minute regarding the amount of pre-deposit I wish to submit. My lord, that this 7.5%, my lord, this I have to pay from my own pocket, whereas the service tax is a tax which is recoverable from the service recipient. In this case, my lord, my service recipient is a government.
Mr. Sharaf, your application, if it is allowed, you'll get back everything. It's a question of law and will be decided.
My lord, but
Subject to
to
hearing
gather
them.
such a huge amount, my lord, wherein I have not recovered it from my party will be very difficult, my lord. Particularly, it is, I mean, I'm a government contractor, my lord. So, my lord, in government contracts, the amount of profit which we earn is very small amount. So, my lord, I am requesting, my lord, it is my humble prayer, my lord, kindly give 5% of the service tax disputed amount will pay, my lord. That is what I'm humbly praying, my lord. Instead of 7.5%,
Where is the mega exemption scheme? Where is the mega exemption scheme?
Mega exemption notification, my lord. My lord, it is on page 22 to 41, my lord. Kindly refer to page 24, my lord, the relevant paragraph. 24.
24 is something else. 24 of your compilation.
Compilation, my lord. Compilation.
And your pleadings are there, I'm sure.
Yes, my lord. Yes, my lord.
Very, very good. Very
Yes,
good.
yes.
No, 24 of the compilation is something else.
No, it is it starts from 22, my lord.
Okay. So give me the first page, then I'll come to that relevant portion.
Yes. Page 22.
And 24, where is it? Clause.
Page 24, my lord, the work which I have done, my lord, it is covered under 12, my lord, 12D. Canal, dam or other irrigation works.
Very well. That's all.
And then, my lord, kindly refer to page 25, serial number 14.
Not necessary. This will do. Yes, Ashok. The present writ application has been filed inter alia. Challenging the show cause notice dated 28 April 2021. Inter alia including the final interiorly including the adjudication order dated 31st of March 2023. Which page? 31st March 2023.
My lord, 138. Page 138 of the petition, my lord.
Thirty-first of March 2023. Issued under section 73. Mr. Sharaf, issued under
Yes, my
section
lord. 73 of the
73
Finance Act 1994.
of the Finance Act 1994. Full stop. The petitioner which is a partnership firm, carries on the business of providing works contract services with government contracting. First up, it is the petitioner's case that in terms of the notification dated, it is terms of the notification number 25/2012 dated 20th of June 2012. The petitioner is entitled to an exemption from the provisions of the service tax in the light of the petitioner carrying out works which are related to providing services to the government or local authority or governmental authority by way of construction, erection, commissioning, installation, etc. in a canal, dam, or other irrigation works. Since the petitioner had been executing works which were exempted by the aforesaid notification. Now, it's okay. Notwithstanding the aforesaid, in the petitioner's case, notwithstanding the aforesaid, a show cause notice dated 28th April 2021 was issued. Alleging violation of the provisions of, kindly hear Mr. Sharaf. Mr. Sharaf, kindly
Yes,
hear.
my lord, I am hearing, my lord.
Alleging violation of the provisions of section 66B, 67 and 68 of the Finance Act 1994, read with Rule 6 of the Service Tax Rules 1994. In respect of works carried out, now, in respect of service tax liability for the financial year 2015-16.
Yes, ma'am. 15-16.
Poster. Although according to the petitioner, the issuance of the said notice, although according to the petitioner, the said notice was barred by limitation, although not. According to the petitioner, the said notice, although not. According to the said notice, the same was barred by limitation, and accordingly, the petitioner had, by its response dated 20th May 2021, highlighted such fact to the authorities and called upon the authorities to withdraw the same. Full stop. Records reveal. Records reveal. Full stop. Full stop. Full stop. The authorities, however, Wait, Alvin. The authorities, however, had passed a final order dated 31st of March 2023, thereby determining liability under section 73 within bracket 1
Yes, madam.
of the Finance Act 1994 and has demanded, where is the demand? Which page?
But that is on page 153, madam.
And has 153. No.
1 second. Madam.
No.
150, madam.
And has demanded service tax amounting to rupees 571 583 within bracket rupees 5 crores 71 lakh 35,583 only from the petitioner. In addition to interest and penalty imposed on the petitioner.
Yes, madam.
Mr. Mr. Sharaf, learned advocate, representing the petitioner. Representing the petitioner by drawing attention of this court to the provisions of Section 73 of the Finance Act 1994 submits that since the issuance of the notice, show cause notice under Section 73 is beyond the prescribed period of 30 months from the relevant date, the entire initiation of proceedings to determine the liability from the determined liability is without jurisdiction and or is valid. He submits that there are other grounds of challenge, other grounds of challenge, including the final order being passed without on the grounds which are not reflected in the show cause notice.
Yes, ma'am.
In support of his contention, show cause notice. By further placing reliance on the provisions of Rule 7 of the Service Tax Rules 1994.
Yes, ma'am.
Submitted that in the petitioner's case, the authorities advised by invoking Rule 7(2) of the opere একটা said rules করে দেবেন না, আর উপর said act করে দেবেন, তাহলে বারবার হলে of the said rules could have initiated the proceedings under Section 73 by issuance of the show cause not later than not later than (25th of October 2018) inasmuch as the outer limit to initiate proceedings in respect of outer limit to initiate proceedings is 30 months from the relevant date. Full stop. Since the proceedings relate to the financial years 2015, 2016, the same ought to have been initiated latest by 25th October 2018.
Yes, ma'am.
In support of his contention that the proceedings initiated under section 73 beyond the period of limitation is without jurisdiction and cannot be enforced, he has placed reliance on a judgment delivered by the division bench of this court in the case of Commissioner of Service Tax -1 Kolkata versus Surya Vistacom PVT Ltd, reported in 2022 within bracket 66 GSTL all capital .290 within bracket Cal. Yes.
Yes, madam.
In the given facts, it is submitted. That's in the given facts, it is submitted that by reasons of the nature of challenge, in the given facts, it is submitted that by reasons of the nature of challenge, the provision for appeal under section 85 of the Finance Act of, this is fine now, under section 85 of the Finance Act of 1994 cannot stand as a bar for this court. 85 of the
It will be 86, my lord. 86 of the finance.
Cannot stand as a bar for this court to entertain the present petition. That is all.
Yes, madam.
He prays for stay of operation of the impugned demand. At this stage, he prays for stay of operation of the impugned demand. Yes, Mr. Bonik. Demand. Mr. Bonik, learned advocate, representing the respondents on the other hand, representing the GST or no, representing the respondents on the other hand, submits. I'm just recording. There is no irregularity on the part of the respondents in issuance of the show cause notice dated 28th of April 2021. Full stop. The petitioner participated in the said proceedings. Opportunity of hearing, personal hearing was duly afforded to the petitioner. Full stop. There appears to be no procedural irregularity committed by the adjudicating officer. Full stop. It is only on the basis of the provisions contained in the final of the said act, that the final order dated 31st of March 2024 has been passed. The petitioner has an efficacious alternative remedy in the form of an appeal. Full stop. The petitioner, in an attempt to avoid, listen to me, the petitioner, in an attempt to avoid payment of pre-deposit, has invoked the extraordinary jurisdiction of this honorable court. In the facts as stated here in above, it is submitted that this court may be pleased to reject the application, dismiss the present application. Yeah.
My target has submitted that their works is for construction of dam.
Sir, on the basis of your submission, I will decide that. You will file affidavit.
Yes. Moreover, it is mentioned just only paragraph.
Without prejudice to the above, he prays for leave to file affidavit in opposition. Without prejudice to the above, dismissal. You don't want to file affidavit. That's why I'm saying, without prejudice to the above, he prays for leave to file affidavit to the present writ application. I cannot decide this today, Mr. Bonik. Then I will stay this without, I will grant a blanket stay if you say.
Their document. It is their document that they are.
I am not going into that issue. I am going to the question of limitation only.
Yes. Demand was made within this specific period of limitation.
Show me.
There was their document. They have also added the DOLA, which I would like to submit.
My lord, may I request Mr. Banik to speak on mic, my lord? I can't hear him properly.
Mr. Bonik, I will hear it finally on affidavits. Let the revenue come, let the amount come in to the coffers of the state. Whatever I direct, let it come in.
Yes.
Thereafter, I will.
Yes. Okay.
So you are
All
today
right,
out of pocket, sir.
All right. My lord.
There is no limitation period of the appeal also. According to you, there is no limitation period.
Yes, there is a limitation period. Within 90 days, they have to prefer appeal before the appellate authority.
Heard the learned advocates appearing for the respective parties and considered the materials and record, having regard to the case made out by the petitioner, and since a jurisdictional issue has been raised, I am of the view that the writ application is required to be heard. However, taking into consideration the fact that the petitioner, that in the event the petitioner had filed the appeal. Now, however, taking into consideration the fact that the petitioner cannot be permitted, taking into consideration the fact that in the event an appeal was preferred, the petitioner would have been required to make a pre-deposit. I am of the view that if the petitioner make a pre-deposit, no, भूल बोल रहा हूँ.
My lord,
just a minute.
My lord, I just wish to point out division bench judgment, my lord, wherein, my lord, there was no, my lord, the division bench, my lord, Honorable Chief Justice admitted this on the ground of limitation and there was no requirement of pre-deposit. My lord, kindly just allow me, your lordship, past judgment as per your lordship, my lord, the judgment, my lord, the very recent judgment, my lord. Just give me 1 minute.
I am directing to put in 5%. Put in 5%, the matter will be heard. Then after, unless you put in the, you see, I have to hear you in that case. In this circuit, it is very difficult to completely hear you. Had it been a principal bank, situation would have been different. I could have disposed of this matter. But today, the time that is required is not available in the circuit bench. So therefore, ordinarily, it is best that you secure this amount and the matter requires exchange to be heard on affidavits also. Also, independent of everything, matter requires to be heard on affidavits. You cannot say that you will shut them out.
No, my lord, I am not saying it.
And taking into consideration that jurisdictional issue has been raised, I am of the view that the writ application should be heard. Also, at the same time, taking into consideration the provisions of section 35 III of the Central Excise Act 1944. Whatever the petitioner cannot be permitted to enjoy a blanket stay. না ওপরে ওপরে লাইনটা কি দিয়ে শুরু হয়েছিল এইখানটা at the same time since the petitioner prays for stay of operation of the demand and taking into consideration stay of operation I am of the view that the petitioner at this stage should deposit with whom
with respondent number.
Well, it is deposited online, my lord. The deposit
Online.
Should deposit with the respondent authorities. With the respondent authorities, 5% of the impugned demand. 5% of the impugned demand.
My lord, impugned service tax demand, my lord. Because the view deposit is on service tax, not on interest and penalty.
5% of the disputed
service tax amount.
Disputed service tax amount. Disputed service tax amount. If the disputed service tax amount, there shall be an interim or there shall be an interim stay of the aforesaid demand. Aforesaid demand, there shall be an interim stay of the demand dated 31st of March 2023 for a period of 7 days from date, comma, if such demand, for a period of 7 days from date, full stop, if within the 7 days, within for a period of 10 days from date, full stop, if within the aforesaid period, the petitioner deposits 5% of the disputed service tax amount as identified in the order dated 31st of March 2023 at page 150 of the writ application. The order dated 31st of March 2020, the demand as contained in the order dated 31st of March 2023 shall remain stayed till disposal of the present writ application. Full stop. Let affidavit in opposition to the present writ application be filed within a period of 3 weeks from date. Reply, if any, thereto.
2 weeks.
ওই না, ওই ডিমান্ডটা স্টে নেয় তাহলে অতদিন তাহলে পড়েই থাকবে। ওই ডিমান্ডটা স্টে ফর shall remain state for a period up to the end of July, August. For the period up to the end of August 2024. Full stop. Let affidavit in opposition. August 2024.
Yes, ma'am.
Instead of till disposal, because I do not know what will happen. Let affidavit in opposition to the present application be filed within a period of 3 weeks from date. 3 weeks to vacation হয়ে যাবে. 4 weeks from date. Reply, if any, there to be filed within 2 weeks thereafter.
2 weeks.
3 weeks. Within 3 weeks
2
thereafter.
weeks.
2 weeks thereafter. Full stop. List this matter immediately after the expiry of the period mentioned above, before the next available circuit bench. I will give you back this book later after this order is uploaded. Mr. Sharaf, 5% I have directed.
Yes, ma'am. May I request 2 weeks time to deposit this 5%?
এটা করে দাও, এই unconditional stay for a period of 2 weeks from date.
No, my lord, for deposit of.
So you have to need an unconditional stay.
No, not unconditional, my lord. I am saying that within two weeks to deposit this 5%. That is what I mean.
Yes, so there shall be an unconditional stay for a period of 2 weeks from date. If within that period, if you deposit within the period of 2 weeks, I'm providing instead of 10 days, I'm extending it.
Yes, my lord. Yes, my lord. Grateful. My lord, serial number 9 is also identical, my lord.
Wait, you have to wait.
Yes.
Yes, call the next panel. ওইটা যাবে, এর সঙ্গে থাকবে সব। Serial number 9টা আছে। Same parties, Mr. Monik, you are there.
No, party is different, my lord. Petitioner is different.
Petition
The
is
issue is same.
Pages are different.
Pages are different, and my lord, the work is the same. The irrigation work, the issue
Let
of
the order
limitation.
be uploaded, come back tomorrow. Otherwise, it will be confusion.
Yes, my lord.
Lot of confusion on Monday, Mr. Sharaf.
Monday.
Monday.
My lord, just yesterday I have received the writ petition in Babon Roxit.
19, I'll be Tuesday. I'll play Tuesday. Very well.
Oh,
I'll pass an order in that matter. Please appear at the time of call.
Yes,
I'll pass an order.
I am favorable.
Mr. Sharaf, I'll pass an order in that matter.
In serial number 9?
9, after when I call it.
Yes.
Yes. Please be there online when I call it.
Yes, my lord. I'm there.
Yes.
Lordship, before calling the list, with my apology, Lordship, I would like to mention one thing regarding.
No mentioning, madam.
Lordship, regarding item number 2, Lordship.
No mentioning, madam. Matter is
Lordship, actually, Lordship, you have directing the petitioner to hand it over the copy of affidavit in service from me, Lordship, but in spite of your direction, now he is telling that we don't have any copy of affidavit in service, Lordship.
Madam, you are my officer. Take inspection from my records.
Lordship.
As an officer of the court, you are always ever take inspection from the records.
Lordship.
এই ইন্সপেকশন উকিল বাবুরা চাইলে সঙ্গে সঙ্গে ইন্সপেকশন দিয়ে দেবে, যা রেকর্ড চাইবে, কোনো আটকাবে না কিন্তু সবাইকে।
Grateful.
And note down from that.
Lordship. Actually, Lordship, what copy he has shown me, that's the A status notice only. Yesterday at 5 PM, he has sent that
Find
copy.
out, find
That is why, Lordship, I want to kind of.
Find out, find out.
Grateful, Lordship.
Yes, Mr. Mitro. London Junior? Yes.
Subject matter of challenge is the order of rejection at page 20.
Rejection of?
Rejection of the application of the petitioner for compulsory appointment as no of the peer marriage.
Matter has to be heard. Matter has to be heard.
But I
Yes, yes.
purely question. Or kindly have a look. The order at page 27. 29. For appointment to the post of the mobile on dying having done of late announcing things no more. With reference to the above later in the above subject and license for me that after publication of the history of the question was from the date of appointment of the momo is between 25 and 40. Hence the matter.
What is no more?
Non-official marriage officer. Husband of the petitioner was a non-official marriage officer appointed by the state government within the jurisdiction of the Kushman. He expired in the year 2019, made an application during the petitioner being wife, made an application within the time stipulated, and that was rejected. Total non-application of mine in a meantime. Why I say? But kindly have a look to the rule first. That is actually next marriage. Page 30. Well, in that case also, the petitioner part for completion appointment part he was allowed, although specifically mentioned that have age is 52 years. Another case, identical case. But kindly have a look to rule page 31 and the appendix I also the book. Marriage officer chapter 2. Rule 3. Declaration of vacancy of non-official marriage officers. The state government shall declare vacancy of non-official organization and invite applications from eligible candidates to an advertisement at least one English daily newspaper and one Bengali daily newspaper having circulation in the state. In case of regular appointment and advertisement is to be published, seeking application from the intending eligible candidate, that is as per rule 3 at page 31. Next, rule 4. Qualification and other conditions of appointment as non-official marriage officer. The applicant shall have the following qualifications. A. He shall be a citizen of India. Provide to India. My brother's copy, page 31. Provide one. This was inserted. Provide to added by notification number 438 jail dated 3rd August 2012.
So where are you reading that?
Page 32 bottom. Rule 4. Page 31 rule 4.
Yes.
Rule 4. Qualification and other conditions of appointment. The applicant shall have the following qualifications. He shall be citizen of India, provided that this proviso was added by notification 438 dated 3rd August 2012, which effect from 30th August 2012. Provided that if any ex officio marriage officer dies or becomes permanently incapacitated due to accident or serious illness while performing the duty of ex officio marriage officer, the state government may appoint any dependent of such ex officio marriage officer to the post subject to the following procedure. If number 1, if any ex officio marriage officer dies of permanently incapacitated due to accident while performing the duty of ex officio marriage officer, his son, daughter, or spouse who lives within the jurisdiction of the child, case of the marriage officer and who has may be eligible or be considered or appointed as ex officio marriage officer within that area. Two, the intended candidate shall be different from the date of death of permanent incapacity as that is may be applied to the registered general of marriage. Specify registered general of marriage. Three, the applicant shall specify the application, shall specify in the application his name, his father's name, date of birth, address, educational qualification, other qualifications, including relationship with ex officio marriage officer who died or became permanently incapacitated due to accident or serious illness, present occupation, legally along with supporting documents. 4. In case of the ex officio marriage officer become permanently incapacitated, the applicant shall submit the original medical certificate to that effect to be issued. I is very important. On receipt of the application, the Registrar General of Marriages, West Bengal, shall consider suitability or otherwise of the applicant to the post of the marriage officer and carry forward the application which is recommended to the state government in the administrative. C. On receipt of the recommendation of the marriage officer, Registrar General of Marriage, West Bengal, the state government may appoint the applicant to the post of ex officio marriage officer. But this is the provision inserted on 30th August 2012. No, anyone, my lord knows it very well that
I don't know.
in case of compulsory appointment, age cannot be a bar for it. It's a special effort. B. He shall be permanent resident of local area. C. He shall not be less than 25 years or more than 40 years as on the closing date of the application. As on the closing date of the application. Wait. The selection process for appointment.
Where are you reading this?
Page 32, BCD.
Yes.
4.1, thereafter the proviso, which was inserted by notification 3rd August, 30th August, by notification dated 3rd August 2012 with effect from 30th.
Closing receipt of the application. Closing date on the receipt. What is the closing receipt?
Receipt of the application matter. That is at page 28. 27, death certificate. Date of death 14th of June 2019, page 27.
No, I'm trying to understand. What is the closing date from the receipt? Language, as on closing date of the receipt. What is the closing date?
Hi, why? Why this clause has been mentioned within the closing date? Kindly handle 1 second, my lord, you speak. Wait.
Advertisement.
Selection process.
Advertisement.
Yes.
Yes, sir.
The similar matters, other matters were taken up. The rule says that the basic qualification is 25 minimum and matter for date of application. The petitioner is claiming as heirs of the X. The rule is there.
Rule is there.
And after that.
What similar matter you said?
Similar order they have annexed at page 36. And that was challenged and the matter is pending. Matter number 131 of 2020.
Oh, yes. Granted.
Granted, but that is presently pending. Appeal is pending.
Today, no step was taken by the state government.
No, appeal is pending.
Appeal is pending, I know.
Yes.
Item number 313 of the monthly list. Till today, nothing has been mentioned before the honorable.
That is separate issue. The matter is pending over the age, regarding the age.
I'll record your submission.
Lordship, I can also file the copy.
Anything else?
Lordship?
Anything else?
No. No, in this case also it is more than 40 years because the section provides the.
Why will I not follow the judgment?
Lordship?
Why will I not follow the judgment?
Because appeal is pending, always appeal is pending before the.
So whenever an appeal is pending, I'm bound to wait.
I have no instructions over whether stay is granted or not. I have to take instruction to that.
If the stay is not, is set aside, only thing I want to know. Stay
No,
is
it is
different.
pending, it is pending. Whether
Stay is different. Is it set aside?
No, it is pending, not disposed of.
Not set aside?
No, it.
Item number
Matter of.
313 of the monthly list.
Is it set aside? I'm asking.
No, it is pending. It is not taken up for here.
I'll dispose it off.
Matter is pending, have to take instruction that whether, what is the stage of the appeal?
You tell me now. I'm asking you, has it been disposed of by
No,
saying
it is pending.
pending? So it has not been set aside?
This point is submitted before the principal bench in an
So
appeal.
not been set aside?
It is pending.
Correct.
It may be set aside, Lord.
If it is set aside, then when it is set aside, everything will be set aside.
Lord.
Till such time you grant. Where is your application?
Page 23.
Exactly, do it dekhne. Date of death?
14th June 2019.
Where was your husband working?
As Nomo, within the jurisdiction of Ujjain.
What is your qualification?
Qualification is LLB.
You are an LLB.
No, I am a graduate. My application was rejected not as
Date of death? Death certificate?
page 27. 14th June 2019.
How do I know that you are no more?
My appointment letter is I have annexed.
Where?
My lord, kindly have a look. Page 25, 26, and a order of extension, everything I have annexed.
Page 25.
25. My husband was a member of the Hospital Bar Council. 23, appointment of non-official marriage officer issued on 6th of July 2000, page 23. You are requested to appear before the selection committee in terms of your appeal.
Not necessary. Thereafter, your appointment, appoint person, such and such.
Page 24.
For a period of?
In for a period, my kindly have a look, page 24, in exercise of the power conferred under subsection 1 of section 3 of the Special Marriage Act 1954. West Bengal special rules, the government is required to appoint the person named in column 1 of the column 3 to be non-official marriage officer for the purpose of the state act rules for the jurisdiction mentioned.
Until further orders.
There is a date of retirement.
What is?
Yes. There is a date of retirement. Previously it was 60 years. At present it is 60 years, most probably.
What is he? What was his age?
Well, kindly have a look, page 24. We could be doing spelling.
I've got it. Thereafter,
Thereafter, page 25.
till he attains 60 years.
Yes.
When did you die? Means your husband died, not you. When did your husband die?
Husband died on 20, page 27, 14th of June 2019.
At the age of? At the age of? Unless you're in a position to demonstrate you're below 60 years of age, you don't get a chance.
Below 60, no one. It's a commission.
Date of retirement is there. Show me that you are below 60 years.
What is the rule?
Are you in a position to show me? You never know what will happen next. If you are in a position to impress upon the court that you are entitled to an order, I'll be with you. If you are not, I'll not be with you. Find out and come back. Mr. Mitro, find out and come back.
We will also instruction on it.
He has not disclosed. Unless he has disclosed his age, the husband's age, I will not grant relief.
I have stated possibly in my readings.
I've seen it is not there.
$54 years. Paragraph 5. At the age of 54 years.
20th January.
Premature death at the age of
20th January 68. Page 17. Mr. Mitro did not go through his field papers.
Yes, sir.
No. Admit card.
This also it is 54.
That is the petitioner, petitioner's,
Husband.
husband, is 70.
This is wife. Oh,
With 17 wife.
husband.
Hus-
Wife is 54.
No, husband says premature death, paragraph 5,
Where is document to that effect? Death certificate?
date page 27.
Does it say 54 years?
Husband.
Very well, I'll provide that subject to
Whatever.
he being within 60 years of age.
But
Naturally.
If the act and in the rule itself.
Your data, your appointment letter, you have accepted. Husband's appointment letter, you have just shown me. Page 25, you have accepted
60
that,
now
Mr. Mitro.
Now currently 65 is the.
Maybe.
Yes.
It is currently 65.
Currently 65, but so far the appointment is concerned, earlier it was 60. Now, at present.
At present means which year?
20, after 23.
Date occurred when? Date occurred 19.
19,
In the year 19, what
It
was
was
it?
60.
60. So Mr. Mitro, it should be 60. Was he within 60?
I have 57.
The present date application, yes.
Now presently she is 57 plus.
He or she?
She.
I want to know what was his age at the time of death.
He was 54.
His age, the gentleman's age.
This is
His age.
Was 54.
54 in 2019.
Okay.
No,
His wife is senior to him.
at that time, whether it was account, it has been clearly mentioned the age of previous suffered premature death and the age of 54.
Where, which paragraph?
Paragraph 5.
They will check it up. The present date application has, I'll provide for that. They will check it up. What can you do? You can only argue the matter to the best of your ability. If the client does not get it, you are not to be blamed. 60. Whatever is the rule, I will not go into. Whatever was the superannuation, date of superannuation as per this.
So far, my knowledge,
I will not go. How do you can vouch for it? Whatever is if he is entitled to it, get.
it's not a service at all.
No, I will not.
Getting salary. No, is getting salary from the.
The present date application has been filed inter alia for a direction upon the respondent to consider the petitioner's application for grant of compassionate appointment as a non-official marriage officer within bracket no more upon setting aside the order of rejection dated 23rd of October 2019 issued by the Registrar General of Marriages, West Bengal. Poster. It is the petitioner's case that the petitioner's husband, namely Arun Singh, who was enrolled as an advocate during his lifetime, upon participating in a selection process, was appointed as a non-official marriage officer within bracket no more in terms of office order dated 16th August 2000. Subsequently, pursuant to and in terms of if in notification stroke order dated 24th of January 2002, appearing at page number 25 of the writ application, the petitioner's husband was appointed no more within the jurisdiction of the Kuch Bihar municipality. Was appointed no more in respect of Kuch Bihar municipality. In respect of Kuch Bihar municipality. In respect of the jurisdictional area forming Kuch Bihar municipality. From the said document, it appears that he was permitted to act as nomo for a period. He was permitted to act as nomo until he attains 60 years of age, or until further orders, whichever is earlier. Unfortunately, the petitioner's husband died on 14th of June 2019. Such fact would corroborate from the death certificate for 2019 to corroborate forward now. 2019. The petitioner had immediately thereafter, the petitioner had applied before the Registrar General of Marriages, inter alia praying for appointment as marriage registrar on compassionate ground. Such application was filed on 27th of August 2019. Incidentally, the said application was rejected by the Registrar General of Marriages, West Bengal, by an order dated 23rd October 2019, appearing at page 29 of the writ application, inter alia on the ground that the petitioner's candidature cannot be considered. Inter alia on the ground that the petitioner's candidature, inter alia on the ground that an appointment to NAMO can only be made in terms of Rule 4C of the West Bengal Special Marriage Rules 2010, which inter alia provides that the age of appointment of NAMO is between 25 years and 40 years. Since the petitioner age exceeds the permissible age under Section 4C of the West Bengal Special Marriage Rule, his case was regretted. Her case was regretted. Mr. Nitro Learned Advocate, by placing before this court the said rules, by placing before this court Rule 6 of the said rules, submits that a proviso has been added in the said rule to offer employment opportunity to the dependent of a deceased NAMO, of a to a dependent of a NAMO who has been either permanently incapacitated due to accident or serious illness, or who has died. By drawing attention, what is it? Who has died while performing duties. First up, according to Mr. Mitro, the said proviso, which has been inserted with effect from 1st of September 2014, and does not lay down any condition that the dependent is required to be between the age of 25 years and 40 years for her to maintain the said application. First up, by referring to by referring to Rule 3, Rule 4, within bracket C, Rule 4, 1C of the said rules, it is submitted that the same is confined to selection process of NAMO initiated through advertisement. Such fact would corroborate from a reading, bare reading from the plain language used in rule 4.1c of the said rules. In the facts as stated here, no, it is submitted that now, by placing reliance on a judgment delivered by a coordinate bench of this court in the case of Gopasina versus the state of West Bengal in WPA 13768 of 2023 on 19th June 2023, it is submitted that in identical set of facts, a coordinate bench
But I must be candid, in that case, my lord, rejection was lacking qualification. Lacking qualification. That was something that went on before and passed the order and set aside the order of rejection. In this case, my claim that where the petition was rejected, referring one.
listen, please. By placing reliance, a coordinate makes you go last line. Coordinate bench by in identity in a similar set of facts, the coordinate bench by placing reliance on rules 6 and 4 of the said rules had inter alia come to a finding that the aforesaid, a conjoint reading of the aforesaid rules leaves the scope for a compassionate appointment on the ground of demise of an appointee under NOMO category, even if the eligibility criteria of an applicant are not fulfilled strictly. Having regard to the aforesaid, it is submitted that in the given facts, the rejection of the petitioner's application is illegal to say the least. The same should be set aside and the respondent should be directed to consider the petitioner's application independent of the application on the basis of the provisions contained in Rule 6 of the said rules. Rule 6 proviso, Rule 6, on the basis of Rule 6 on the basis of proviso to Rules 6.1 on the basis of Rule
4 and 6 is same.
No.
Yes, Lord.
No.
4 proviso.
No proviso in 4.
Yes.
On the
there is a
basis
proviso.
of
Proviso
Rule 6.1 of the said rules.
there is
Yes,
a
very
proviso-
slow.
Proviso in 4 also, same proviso. 4.1a. Provided that it an official manager officer dies or becomes permanent resident, the same proviso.
Yes.
Before-
This has been interpreted by Justice Bhattacharya. Mr. Borman, learned advocate, representing the state respondents, on the other hand, submits that in order to be eligible, that for the applicant to be eligible for consideration, even on compassionate grounds, she must be in a position, must have the requisite qualification as regards the conditions of appointment as a NAMO. Admittedly, in this case, the petitioner is beyond 40 years of age. Having regard to the aforesaid, her candidature was rightly rejected. By referring to the judgment delivered by the coordinate bench of this court in the case of Gopasina, it is submitted that the said judgment is pending consideration in an appeal before the Honorable Division Bench. And at this stage, this court should not place reliance on the said judgment for the purpose of granting relief in favor of the petitioner. That is all. Anything else? But the landed advocates appearing for the respective parties and consider the materials on record. Admittedly, in this case, admittedly, in this case, I find that the petitioner. Now, admitted, it is not in dispute that the petitioner is a dependent, was a dependent of Arun Singh, of what is the name?
Arun Singh.
Of Arun Singh, who was appointed as an amo. Full stop. It is also noticed that the West Bengal's, it is also noticed that the said rules inter alia provide for. Now, inter alia provide for a legal right, provide for now confer the legal right on a dependent of a deceased or a permanently incapacitated NAMO due to accident or serious illness to be appointed as an NAMO subject to the procedures as laid down in Rule 6, in the proviso to Rule 6.1 of the said rule. To more fully appreciate the same, the relevant portion of this said rule or relevant portion of the proviso to Rule 6.1 is set out here, is extracted here in below. It would, however, appear that the Rule 4 of the said rules, it would, however, appear that the Rule 3 and Rule 4 of the said rules provide for declaration of vacancy of the non-official marriage officer. Now, Rule 3 of the said rules provide for declaration of vacancy of the non-official marriage officer of the NAMO, while Rule 4 provides for the qualifications and other conditions for appointment as a non-official marriage officer of a NAMO. First of all, a conjoined reading of Rules 3 and 4 would make it explicitly clear that the qualifications required for appointment of NAMO are in relation to an advertisement, in relation to a selection process initiated on the basis of an advertisement published. Full stop. Having regard to the aforesaid, it is clear that Rule 4.1, proviso to Rule 4.1, proviso to Rule 4.1 C, na proviso na. It is clear that Rule 4.1C refers to the qualification of a selection process, qualification of NAMO initiated through a selection process initiated on the basis of a selection process through an advertisement, as the same refers that the applicant should not be less than 25 years and more than 40 years as on the date of closing of the receipt of applications. Full stop. I find now it may, however, be noted that in the proviso to Rule 6, although qualifications has been set forth, qualification for appointment has been set forth, there appears to be a conjoint reading of rules 4 and rule 6 of the said rules, inter alia, encompass within itself the opportunity to offer relaxation to a dependent, offer relaxation of the relaxation of some of the eligibility criteria, of a relaxation to the eligibility criteria, and an applicant's candidature may be considered, notwithstanding the applicant may not strictly fulfilling all the eligibility criteria as provided for in Rule 4 of the said rules. Having regard to the aforesaid, I am of the view. Now, the aforesaid finds support from the judgment delivered by the coordinate bench of this court in WPA, coordinate bench of this court in the case of Gopasina. Having regard to the aforesaid, I am of the view that the register of since a legal right has been conferred on the petitioner to apply for appointment on compassionate grounds, the respondents or the respondent, the register, who is the respondent number? The respondent number 3 ought not to have rejected the application filed by the petitioner on the ground that the age of appointment of NAMO is restricted to 25 years and 40 years, restricted between 25 years and 40 years. So in view thereof, while setting aside the aforesaid direction dated, aforesaid order 23rd October 2019, I direct the register. I direct the respondent number 3 to reconsider the petitioner's application in the light of the observations made herein, and to consider the relaxations that may be granted in favor of the petitioner, and to consider the relaxations that may be granted in favor of the petitioner. And if the petitioner is otherwise found eligible, to appoint the petitioner to the post of non-official marriage officer as per the West Bengal Special Marriage Rules 2010. First of all, formalities in this regard must be completed by the respondents within a period of 4 weeks from the date of communication of this order. We আগের ক্লায়েন্টটা কি বললাম, কনসিডার যেটা বললাম, কনসিডার বললে আর হবে না, কিছু করবে না। না করুন না। And should consider the relaxation and should consider the petitioner's case. না আবার পড়ুন ওই জায়গাটা, সরি। And to consider and to grant relaxation না ওই in light of the observations made here আর কি দরকার নেই এটা বললে আর করবেই না কিছু with the observation and directions the writ application stands disposed of it shall be no address to question.
On page 27, if the application has been cleared outside, the town of 8 of their city.
I have not gone into that question. I mean,
Action number 5, I appear for the petitioner.
Yes, who's for the petitioner? Degi. Degi dao.
I appear for the petition, Your Lordship. Item number 5.
Degi dao. You paid the cost. Paid the cost.
Am I audible to Your Lordship? I appear for the petition, Your Lordship.
Yes, you paid the cost.
Yes, Your Lordship, I paid the cost.
Yes. 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 What is your
Lordship,
challenge?
Item number 5 and 6, Your Lordship, are identical matters.
Yes.
Now, the petitioners have thrown a challenge to the entire disciplinary proceeding, including the charge sheet, the order of punishment, and the order of the appellate appeal. Now, to be fair to Your Lordship, there is no scope for an interim order.
Dismissal affected?
Dismissal effected, I have been rejecting service and challenging that I have preferred an appeal, appeal to dismiss. Now I have approached the Supreme Court by way of the present petition.
Appellate authority decided this in 2020. When did you file the writ application?
Your Lordship, the appeal was dismissed in 2020. After that, a writ petition was filed in 2021, but that was withdrawn. I am ordered dated March 2023 with the liberty to file approach.
Can't hear you anything. Understand, Buldi person. Since full stop, peruse the office report. Peruse the office report, full stop. Since it appears that in terms of the order dated 3rd of October 2023, the petitioner has deposited a sum of rupees 20,000. The District Legal Services Authority. Full stop. The original receipt issued by the District Legal Services Authority is also found on record. Full stop. Heard the learned advocates appearing for the respective parties. Having heard the learned advocates appearing for the respective parties, I am of the view that the writ application can only be decided on the basis of exchange of affidavits. Full stop. Since there is no scope for passing of an interim order, let affidavit in opposition to the present application be filed within a period of 1 week from date. Reply, if any, there to be filed. Cost, I'll impose cost of 20,000. I'll record. Yes, record this. I'll record. Pay 20,000 rupees cost. Why not? 8 weeks you're asking for. So, matter of 2020, within a period of 2 weeks from date, reply, if any, there to be filed within 1 week thereafter. 2 week, 1 week. 2 weeks, 2 weeks. 2 weeks, 2 weeks. Full stop, reply for 2 weeks. List this matter. This matter immediately after the period of exchange of affidavits as directed here and above, before the first available circuit bench.
Item number 6, your lordship, also similar matter.
No. But you challenge everything, show cause, everything you challenge.
Everything. I have challenged the charge sheet, the findings of the inquiry officer, the punishment order, as well as the order of the appellate authority.
You have been dismissed or removed?
Dismissed from service.
After line, filed. Having heard the learned advocates appealing for the respective parties and taking into consideration the fact that the petitioner has been dismissed from service. তারপর কি ছিল? Since there is no scope for passing of interim order. Where is the order of dismissal?
Lordship, page 107.
Dismissal or removal?
Lordship. This page 108, your lordship, second last line, punishment of dismissal from service.
108 is not.
108, second last line, punishment of dismissal from service.
After a division bench order of Justice Dotto.
After a division bench order.
Dismissal.
The division bench order, your lordship, will find at page 96.
Yes.
That's the same order in item number 5 and 6.
6 also same, dismissed from service.
Same charge sheet, same, everything same.
What is the charge? What was the charge against you?
Charge was theft of railway items.
Yes.
7.
Grateful.
In-service teacher who in furtherance of his higher studies had applied for a regular PhD course, which has been accorded by the management quality of the particular school, but subsequently when he was admitted in the particular PhD course, he was denied to get release or he was denied to get his leave, study leave. This is the issue. First round of litigation, the coordinate bench of this High Court directed the headmaster to take a decision in terms of the law. And the decision was in pursuant to the direction. A decision was taken out, it was made and it was communicated.
Why he was not granted leave?
Because the include memo that we had taken the last page of my application, it has stated that the authority is not the competent person to take the decision, rather the board. The board is the competent person to take the decision. This is their stand. Subsequently, however, the student himself has allowed me to apply for a PhD course and subsequently it has taken a resolution in the managing committee also. However,
but the decision is required to be taken by the board, sir.
I leave to attend my PhD course and all.
Otherwise, this will not be regular. Only thing you can get your educational qualification enhanced, it will not be regular. You cannot take advantage of that later. Yes. Why not permitting him? School or the board?
So I am for the respondent numbers 1 and 5.
Board?
No, not the board.
Who are you?
I am the state as well as the DI schools.
So you are DI of schools. DI will recommend. School will recommend. DI will consider and recommend.
Is the board.
Yes. Board will be final authority. Where is your recommendation? Where is your recommendation? Have you considered the case? Why? Have you rejected it?
Yes, the recommendations have been rejected.
Oh.
Because.
But if he says so rejected, then you have to take steps. Then I cannot. I do not know. You also do not know.
Firstly, the
Managing committee recommended.
No objection. But later, subsequently.
Why did the board reject?
Board did not.
Board did not reject, but DI rejected.
I also did not reject.
Who rejected?
Nobody rejected. The problem is.
Take instructions, come back.
Yes, I have got the instructions.
No. What instruction? Don't hand over to me. Instruction. That is your instruction.
Direction was earlier passed by the coordinate date that means that date and the coordinate 28th of November 2023. That board was directed to come up with the latest situation.
Where is board? Where is board? Where is the board?
Board has been direct, they have their separate councils.
Serve. Since the board is not represented, serve and come back. Since the respondent number, since the respondent number 2 is not represented, let this matter stand adjourned and appear under the same heading on Wednesday. Not today, no. Wednesday. Full stop. The petitioner is directed to communicate the aforesaid order to the respondent number 2 and to file an affidavit of service. Any advocate was appearing for them?
No.
To the respondent number 2 and to file an affidavit of service to that effect when the matter is taken up next. Yes, call the next matter.
8.
Respondent number, petitioner, serial number 8, virtually,
Yes.
But I'm for the district primary school.
What is the matter?
Blood suspension in 2018, thereafter suspension not revoked. Allegation of a criminal case, he was arrested, detained for about 10-11 days, arms act, not connected with service.
Yes.
The suspension, challenging the order of suspension.
Where are you working? Where are you working? Who are you?
Well, petitioner is working as an assistant teacher in a primary school under Alipurdwar West Circle. Petitioner was appointed, my lord, as an assistant teacher, my lord, on 13th of February 2017. Well, thereafter, on the basis of a counter FIR, allegation on the basis of a counter FIR, I have been arrested, and my lord, 11 or 12 days I was in detention, and thereafter I have been suspended.
In custody?
And suspension, yes. Suspension is long pending, my lord. My lord, now question is whether the suspension will be continued or suspension will be revoked.
Suspension cannot be, why inflicting a punishment on me in the form of suspension?
Where
rules, various rules, any appellate rules, rules for appeal.
Appeal rules is there, Millard.
File an appeal. I'll grant you opportunity.
My lord, there is certain, my lord, there is no such appellate rule is there.
Same, there is an appeal rule to prefer an appeal.
My lord, I am placing certain authority, my lord, regarding this issue.
Not necessary. Not necessary.
The issue has been decided by the Honorable High Court.
Question is whether you can continue with the order of suspension for unlimited period.
We cannot.
Right.
Then
suspension is continuing since 18.
Then
but kindly, Millard, I will, Millard.
Record your submission.
Millard, kindly record, Millard, that Millard, as such, Millard, there is nothing to object in this, Millard.
Then why are you not lifting? No, someone is responsible for this. Who has continued with the order of suspension?
Chairman of the DPSC.
Where is he? What is his response to that? Where is the affidavit has been filed?
No, Millard, affidavit has not been filed by him. The 2018 suspension, that is Millard admitted.
Millard, subject to
subsistence allowance has been paid. Subsistence
what will happen to this period? Are you interested in initiating any disciplinary proceedings?
No, my lord, we cannot also, as it's not connected with.
That is entirely up to you. I will not go into that.
Disciplinary proceeding has not been initiated.
Lord, your lordship, before passing the order, your lordship, may I place the one judgment, my lord? In this issue, it has been decided.
I am sending it back to the authorities for reconsideration.
My lord, before that, your lordship, kindly have a look for a moment. Before that, my lord, my junior is there, Mr. Arijit Ghosh. Arijit, I request Mr. Arijit Ghosh to hand over the judgment of WPA number 8304, dated by 13th March 2024, my lord.
The
13th of
present
March.
application has been filed inter alia.
Latest judgment. Your lordship, kindly have a look. The judgment for a
Questioning
moment, my lord.
inter alia praying for revocation of the order of suspension dated 12th of November 2018 issued by the respondent number 5.
Arijit judgment of the
The petitioner. The petitioner.
I mean, 8304.
This is on affidavits. This is on affidavits.
No, affidavit is not required in this matter. Factually,
if you want to rely on that judgment, then I will. If
denied.
you want to rely on that judgment, then I will rely on the entirety of the judgment.
Yes, my lord. Your lordship. Yes, your lordship, kindly have a look, then pass the order.
Petitioner had joined as an assistant teacher in. The petitioner is an assistant teacher. In Simalbari, SPL.
Shimlabari. Shimlabari, SPL.
Shimlabari, SPL within bracket, stroke C, primary school. Why have you not made it a party?
Primary school.
Yes.
School, well, village education committee of the Shimlabari Special Cadre Primary School has been made party. Well, school, there is no such role as such of the school authority.
You are working there.
Yes.
I need to see. I would have heard the views of the school. Why they not interested to see you? In an event, you cannot continue in this particular school. They have to transfer you to somewhere else.
No, transfer right now, may transfer. That is subsequent issue. Transfer is
once it is revoked, I'll direct them because
yes, it can be. Yes, can be. Once it is revoked, can be. They are able to. But there is no issue. I am not objecting that.
Because how can you continue in this particular school? After all, at the end of the day, you are carrying with you the stigma of arrest.
My lord, regarding this, my lord, your lordship, kindly have a look the judgment that the stigma
records reveal that the petitioner was placed under suspension on 13th of February 2017. Placed under suspension by an order dated 12th of November 2018. Full stop. According to the petitioner, he had been falsely implicated in a criminal case with the Alipurduar PS case number 381 dated 30th October 2018 under sections 341/506 of the Indian Penal Code, as also under the provisions of section 25 within bracket 1 within bracket A stroke 27 of the Arms Act. Arms Act. Yes, sir, Arms Act 20?
Arms Act
19, which year? 68.
But, 1959.
Arms Act 1959.
59.
It also appears that the petitioner was detained in police custody for the period between 1st of November 2018
till 12th of November 2018.
12th of November 2018. Full stop. Any criminal proceedings initiated?
Disciplinary proceeding not initiated.
Any criminal proceedings initiated?
This is the only proceeding.
Yes,
where is that? Where is the disclosure? Where is the disclosure?
That is the that I have annexed.
Where is the
Page
disclosure?
24, that is the page 24. Page 24 onwards, page 24, 25, 26, 27.
Have you been acquitted?
No, I have been granted bail.
At present, the petitioner has been enlarged on bail, though the criminal proceedings initiated against the petitioner on the basis of the FIR in Alipurduar PS case, Alipurduar PS FIR number 380.
381.
380.
381.
381.
No, my lord. 381. Page 24.
Alipurduar, what is page 22? 380?
Page 22, that is my complaint, my FIR, and that is their FIR is the counter FIR, my lord. Counter allegation.
Page 380, FIR number 381 dated 30th October 2018. শুরু হয়েছিল কি দিয়ে লাইনটা? At present, the petitioner is on bail, has been enlarged on bail.
381
is still pending. Full stop. Mr. Ghosh. Mr. Bose, learned advocate, appearing on behalf of the appearing in support of the present application, submits that the aforesaid order of suspension has been issued in violation of the provisions of West Bengal primary education within bracket conduct of service of teachers of primary schools bracket close rules 2001. By drawing attention of this court to the order of suspension, he submits that the said order of suspension does not identify either explicitly or impliedly that the same has been issued in contemplation of any inquiry proceedings.
No, there is no such inquiry proceedings have been initiated by the board or the primary school council.
Full stop. The petitioner has been kept under illegal suspension since 12th of November 2018. Full stop. It is submitted that a suspension cannot continue indefinitely without the respondents initiating a disciplinary proceedings against the petitioner. Admittedly, since in this case no disciplinary proceedings has been initiated, the petitioner, the aforesaid order of suspension should be revoked. Full stop. It is still further submitted that the aforesaid revoked. Full stop. Mr. In support of his contention, he has placed reliance on a judgment, on an unreported judgment delivered by a coordinated bench of this court in the case of Sarup Chandra Bishoi versus State of West Bengal and others in WPA 8304 of 2022.
Well, there is scheduling of judgments regarding this issue.
13 March 2024. Full stop. Mr. Sachdev, learned advocate, representing you are representing
DPS.
Director of Public Education.
Respondent number 3 million to the District Primary School Council.
Okay, you are appearing on behalf of the respondent numbers?
We are 4.
4, 5.
4 and 5.
Representing the respondent numbers 4 and 5. On instruction submits that submits that the aforesaid suspension order submits that although the aforesaid suspension order was issued immediately upon the petitioner being arrested, the same has not been issued in contemplation of any inquiry proceedings. Full stop. At present, the respondents also do not intend to. You are the issuing authority.
I'm the issuing authority.
Do not intend to initiate any
Disciplinary proceedings.
proceedings against the petitioner. Full stop. Having regard to the aforesaid, and since the petitioner should not have been kept under suspension for a prolonged period without holding any inquiry against the petitioner, and further taking note of the fact, further taking note that a suspension cannot be imposed as and by for punishment without holding any inquiry. I am of the view that the aforesaid order of suspension cannot be sustained. Aforesaid order of suspension cannot be sustained. Which paragraph do you want to rely of the judgment?
18, 20, 22, 23.
These are different facts. Where it's in contemplation of a departmental proceedings. Yes.
No, my lord. The criminal proceedings has been initiated against the petitioner in the cited judgment. My lord. The same fact. My lord, your lordship kindly have a look at the fact of the case. My lord, that is paragraph 5. In FIR being all women police station Jhargram case, so and so. Under section 341, 354 of the Indian Penal Code and section 8 of the Protection of Children from Sexual Offences Act, the petitioner was
it is also noted that in a particular set of circumstances, the coordinate bench of this court,
same fact, madam. Similar
in the
fact.
case of Sarup Chandra Bishui,
And when the rule itself says that proviso is there that without recording any reason, the suspension order cannot be continued for a prolonged period.
has interfered with the order of suspension. Admittedly, in this case, where is the rule? Relevant rule? 7(1).
Well, 4A. So yes, 7
Yes.
by 4.
Where is the rule, sir?
Rule is, my lord, the West Bengal Primary Education Conduct of Service of Teachers of Primary School Rules 2001. Rule 7.
Admittedly, I find that Rule 7
Rule 7
said rules of the said rules
4A.
inter alia provide the circumstances under which a teacher can be placed under suspension although Rule 7(1) B of the said rules inter alia provide that a suspension order may be issued where a case of criminal offense involving moral turpitude against the teacher is under investigation or trial, comma, the order of suspension does not highlight invocation. Order, which page is order of suspension?
Page 29.
Does not highlight that the same has been issued by invoking the provisions of section 7(1)(b).
West Bengal primary education.
The name of the rule is West Bengal Primary Education Conduct of Service of Teachers of Primary Education, Primary Schools Rules 2001. Rule 7B and 7/4A.
Why not 7B?
Well, 7B also, yes, certainly, madam. I bow down to your lordship, madam. 7B also. Yes. And as well as I'm saying.
No, under 7B, you can be continued to kept under suspension.
No.
Why?
Well, that is
Arms Act. This case involves Arms Act.
Your lordship, kindly have a look.
I see only
Well, 7/4. A teacher under suspension or deemed to have been suspended shall be entitled to the following payments. 4A. During the first 3 months of suspension, a monthly
sir,
subsistence
kindly understand what is going on here.
My
You are arguing something else. 7(1)(b).
My lord.
The case of any criminal offense involving moral turpitude against the teacher is under investigation or trial. I'm trying to find out whether this is a case of moral turpitude or not.
No.
Understand what is being considered here.
Yes, I have told my lord that there is no such.
Yes, Ashwin. No. So it does not appear from the above that, yes, sir, this is not a case of moral turpitude, because moral turpitude is where dishonesty or
case.
immorality is in question. But immorality is here
Relating to service.
It's not related to service admitted, but Arms Act is there.
Yes.
একদম Arms Act 25-27 দুটো আছে। Primary education act
This is on this issue only.
The case which has been shown to your lordship was under POXO Act. But
That is different.
similarly, on the expression moral turpitude would also include say a case of murder. Even if morality as such is not involved, but turpitude is always there.
That is POXO.
This
That
is
is
the-
different.
That is the counter FIR. That is the counter case.
This does not appear to be a case where the petitioner moral turpitude. This issue did not fail for consideration in the other judgment, sir.
No,
Moral turpitude was not considered.
no.
What is the meaning of the expression moral turpitude in relation to service?
There are judgments, I'm not carrying those. My lord, kindly takes it up, my lord.
Yes.
Tomorrow.
No.
Because moral turpitude in light of 7B has to be said.
Yes.
What does it mean? I received the brief yesterday night.
Come tomorrow.
So I could not also prepare my.
I'll complete it tomorrow. Tomorrow morning.
Yes.
It will appear at the top tomorrow. I want to clarify this situation.
My lord, in that case, my lord, if your lordship place it similar position, then I'll go to the circuit bench and it may be placed before your lordship physically.
Tuesday.
No, tomorrow. Tomorrow.
ঠিক আছে দিক না আসুক না
I will be there, no difficulty.
tomorrow. Yes. সকালে টপেই দিই না আসুক তারপরে পাস ওভার করবো চেঞ্জ করবেন না থাকবে Yes, call the next matter.
Item 9, my lord.
Yes, let this matter. Yes.
Mr. Vinesrab is leading, my lord. He is appearing on another courtroom, my lord, by
On Tuesday.
No, my lord, I'm praying short pass over, my lord.
No, Tuesday.
My lord,
once I upload the other order, I will pass the similar order in this matter.
Then, my lord, Monday, perhaps, my lord, our division bench, Honorable Chief Justice on Tuesday, my lord. So I do not know the program of
Monday.
Monday, my lord.
Monday. 9 on Monday. List this matter on Monday.
My lord.
You are asking for an adjournment. I remember that.
Yes.
Since an accommodation has been sought for on behalf of the respondents, let this matter stand adjourned and appear under the same heading on Monday next.
Kindly fix it Tuesday.
Here's some problem. Division bench is there. Tax matters are taken up before the division bench. Honorable Chief Justice takes up tax matters on that particular date. How can I take it up?
Wednesday.
The appeals are before the no. Wednesday. Let it be there on Monday. I'll complete this on Monday. Call the next matter.
My lord, subject to correction, my lord. And yesterday, my lord, another one matter mentioned that WPS.
Don't mention now. This is not the time for mentioning.
My lord, I'm extremely sorry. I'm grateful.
He mentioned for tomorrow.
Tomorrow, I know. No.
Yes.
Oh, tomorrow you will be there.
We are from Darjeeling.
I know. Tomorrow it will be uncertain. Some matters will be decided tomorrow. Dako.
Lordship, in this case, we are for the respondent. I apologize for not being able to present the affidavit, which is almost ready. My lord, let me finish.
Why is that matter appearing under the hearing
protection from Mr. Ghosh's intervention?
এটা মোশনে এসছে কেন এই মামলাটা হিয়ারিং লেখা আছে এত বড় চোখে দেখতে পাচ্ছ না এত বড় করে
Then item number 64 of your lordship, this is the same matter. Analogous matter.
Similar matters both were mentioned. One came under the heading here.
এখানে দিয়েছো কেন না পাঠিয়ে দাও ওখানে Prepare your affidavit.
No. It is ready, only needs to be affirmed.
Prepare your affidavit. Prepare and come back. It will be taken up. Yes.
64
It will go ahead. ওটাকে নামিয়ে দাও কালকে ওইখানে শুধু ঢুকিয়ে দাও 64 এর সঙ্গে দিয়ে দাও 64 এর সঙ্গে দিয়ে দাও এটাকে
Grateful, my lord.
উইথ দেবে না পরে দেবে কোনো উইথ করবে না কিন্তু অর্ডার নেই কোনো ইয়েস দাও
Your Lordship, I'm praying for short passover.
No, madam, no passover. Petitioner is there. Continue.
On the last occasion, the respondents filed a report in the form of affidavit, and I am filing today the exception of the said report, lordship.
Exception?
Exception to
So
the.
why you mentioning as motion? Dekhi? affidavit হয়ে গেছে। সব affidavit ডিরেকশন হয়ে গেছে। এই তো affidavit ডিরেকশন। What is the matter?
Lordship, the petitioner was suspended. He is a state aided college teacher working in a state aided college and he was suspended. And during his suspension, he is in suspension, Lordship, and he has not received a single penny as a suspensional allowance, Lordship.
Subsistence allowance.
Subsistence allowance, Lordship. So,
Yes, madam, where is the subsistence allowance? Where is the order of suspension?
I'm coming to that order, Lordship. At page number 17 of my read application, Lordship.
You'll be there tomorrow?
Lordship.
Or you have difficulty tomorrow?
Lordship, I'm from Siliguri, so I have difficulty. I want to.
Your matter is connected matter, I'll take up tomorrow. Identical. I would have disposed of the writ application.
Lordship, if possible, kindly read today. If this.
Tomorrow I will place it, but tomorrow with the other matter, you were hearing the other matter suspension, same. He was a case of POXO.
Lordship.
And the court interfered in that case.
Lordship. But tomorrow I have difficulties, Lordship, because I'm from Siliguri and.
Monday. Please this matter on Monday.
Kindly take this.
থাক না অতটা তোমার অসুবিধা কি আছে হ্যাঁ Monday. Since an accommodation has been sought for on behalf of the respondents, let this matter stand adjourned and appear under the same heading on Monday next. Let the exception in the form of an affidavit filed on behalf of the petitioner to the report filed on behalf of the respondent numbers 1, 2 and 3 be taken on record. In court today. Madam, get ready and come. Final hearing Monday.
Lordship, I'm for the petitioner.
কোনটা? এই তো এই যে কারেকশন ডিপার্টমেন্টে কারেকশন আছে, ডিপার্টমেন্ট করেছে, দেখো পরের দিনে অর্ডার আছে, পরের দিনে অর্ডার আছে। Yes.
Lordship, I'm for the petitioner.
What's the matter?
Lordship, it is an analogous matter which appeared before Justice Aniruddha Roy.
Yes.
In last circuit, and he was pleased to pass the same order, which is interim protection to your.
I do not know.
Lordship.
I do not know. I have not seen the interim protection. What is your matter? You tell me.
Well, they are challenging in this report that the levy on plywood and veneer matter, that matter. But initially, Justice Shamapti Chatterjee passed an order whereby the notification for levy on market fee on plywood and veneer was set aside, my lord. And pursuant to that, further notification was published at page 56, my lord.
Yes.
And thereafter, my lord, Justice. That is the question, my lord, whether it is an agricultural produce or not.
We are seeking the same relief.
If you also kindly see page 60, my lord. This is the order last passed by the in the principal bench by Justice Tapabrata Chakraborty, wherein levy has been stayed, my lord. And thereafter, appeal has been preferred. 3 appeals are pending, my lord.
Lordship, they are lying.
In the principal bench, my lord.
You are challenging this notification. Yes?
Lordship.
Where is your prayer?
The fact remains that we are not leaving anything leaving any fee on.
Where is your challenge to the notification
Page 20.
dated 24th July 2017 in your prayer portion?
Not there.
Yes?
Lordship, we are.
Madam, are you aware of the facts?
Yes, sir.
What are the facts?
Sir, in this petition, two contention was raised. First was whether market fee can be imposed on the sale transaction of the veneer or plywood in the market area or not. And second point is, Lordship, whether market fee can be imposed on import of the veneer and plywood.
Where is your prayer to that effect? 17A of the West Bengal Agricultural Produce Act.
Yes, Lordship.
Huh.
Prayer B.
Where is that notification?
Lordship,
Where is that act? Where is that act? Agricultural Produce Act, where is that act?
Agricultural Act. Madam, notification as page 56, type copy at page 58. Write this notification, my lord, ex miscellaneous.
This has been included.
Included, ma'am. Thereafter, Justice Chakraborty state this notification, and their claim is that we are levying fee. But our stand is that we are not levying fee pursuant to that order of the Honorable High Court. There is a stay on that.
You are living under which provision?
My lord, pursuant to this notification, we are not.
You are living under which provision?
No, we are not levying any fee.
Then?
They are apprehending that we levy, we are not levying any fee.
I'll record your submission.
Yes, but record that. We are not levying any fee. Can you record that, madam?
Lordship, they are.
No. Show me one instance from the annexures that we have levied fee. There is nothing on record.
Where is section 17A of the Agricultural Produce Marketing Regulation Act 1972? Yes, you have a copy, madam.
I'm getting a copy of it.
That's why I'm asking you. You have a copy. I know you are assisting. That is why I'm asking you. Yes. You have not brought a copy, madam. You have come here to move a matter. How will the court pass an order in your favor? Because another coordinate bench has passed. How will I know under what circumstances that order has been passed?
Lordship, I have given the order.
That will not help you. I have to apply my mind in the matter, and thereafter I have to pass simpliciter. If you show me there is an order and pass the same order, why will I pass an order in your favor? Yes. Yes, 17, levy of market fee. The petitioner, the petitioner the present writ application has been filed inter alia, praying for anything in the nature of mandamus so as to direct the respondents and each of them to forbear from collecting levy of market fees on plywood and veneer from the petitioners in any manner whatsoever by invoking the provisions of section 17 and 17A of the West Bengal Agricultural Produce Marketing Regulation Act 1972, hereinafter referred to as the said act. Mr. Miss such and such learned advocate representing the petitioner by placing before this court
This 32 is the first order passed by this honorable court, my lord, wherein
the Justice Chakraborty's order?
Yes, my lord. That is at page, my lord, 60.
By placing before this court the judgment delivered by a coordinate bench of this court in the case of Shoshi Timber and Plywood Industries PVT Ltd and others, in WP 9042W of 2018 on 4th July 2018 submits that the coordinate bench has been entirely pleased to restrain the respondents from giving effect on a further effect to the notification dated 24th July 2017 issued in exercise of powers conferred under subsection 1 within bracket A of section 2 of the said act. Since the said notification has been said,
Page 56.
where is veneer within this?
X, miscellaneous, veneer and plywood, page 58, my lord, included. 22 and 23.
Since the aforesaid notification has been stayed, the effect of inclusion of veneer and plywood under the miscellaneous head also cannot be given effect to by the respondents, and no fee under section 17 within bracket 1 of the said act can be collected from the petitioner. Mr. Pal, learned advocate from the petitioner, full stop.
First one of the appeals have been preferred, my lord.
He says she further submits that in identical set of facts, this honorable court no, full stop, document. Mr. Pal, learned advocate, representing the respondents on the other hand, representing respondents, submits that the issue as regards the stay of notification dated 24th July 2017, the issue as regards grant of stay to the notification dated 24th July 2017 for subject matter of challenge in an appeal being MAT 960 of 2021 from subject matter of appeal in MAT 960 of 2021, MAT 1257 of 2021 and MAT 686 of 2017, which is at present pending before the division bench of this court. He submits that in identical set of facts, this honorable court had been pleased to dispose of the writ applications by making the interim order absolute, subject to final decision of the appeal pending before the division bench. Having regard to the aforesaid and taking into consideration the fact that in similar set of cases, in similar set of facts, coordinate bench, in similar set of facts.
No, here the order is slightly different because here there is stay on inspection also.
Where?
Which in this order, the order.
I'm not going to that.
Yes, ma'am. Which will trouble us because what is in there, if we can't inspect.
কি শুরু করেছিল? This court has been pleased to he disposed of numerous writ applications. Heard the learned, consider the materials of the record. I find that in numerous repetitions are pending on the identical issue, and various orders have been passed by the coordinate benches. Full stop. However, taking note of the fact that the notification dated 24th July 2017. How can it? I'm just affidavit or I'll
Yes,
invite affidavit.
Yes, Malord, I'm grateful.
Because it was not finally heard.
Yes.
Read petition was not finally heard. Yes, madam.
Lordship, we are seeking the same relief.
How?
Lordship.
Read petition was not finally heard.
Then Lordship, keep this matter on Tuesday or Monday.
No.
Lordship, Mr. Jagriti
Malord
Mishra
can
will
record
Then
our
you ought to
submission
have
that we are
thought
not
of-
leaving any fee on those items, Malord, can record that submission.
वही आगे line है, Mr. In an event, Mr. Pal submits that the respondents, in terms of the
Order passed on
in terms of the order passed by the coordinate bench of this court on
4th July 2018.
4th July 2018 has not levied any fee
Yes, ma'am.
under section 17(1) of the said act. So, how the learned advocates appealing for the expiry and consider the materials on record.
With regard to
It is noted that numerous petitions are pending on numerous read petitions have been filed. Numerous read petitions have been filed on identical issue. It also appears that by an order dated 10th April 2024, a coordinate bench of this court taking note of the division of the stay of operation of the notification had been pleased to make the interim protection absolute, had been pleased to make the interim protection as regards grant of stay of the notification dated 24th July 2017 absolute, pending final disposal of the appeal by the division bench. Having regard to the aforesaid, I am of the view that the present writ application can be disposed of by recording, but may be disposed of by affording similar protection to the petitioner. With order and date policy in WPA 373 of 2024, Messrs. Mahakal Industries and other versus State of Illinois. Having regard to the aforesaid, protection to the petitioner. Having regard to the aforesaid, I am of the view. Hey, dispose of people. Having regard to the aforesaid, I am of the view that similar relief. I am of the view that the petitioner is entitled to interim relief as prayed for. Full stop. The aforesaid writ application, interim relief as prayed for. Full stop. Since no useful purpose will be served.
Since the original writ is pending, Malord, against which these orders are passed, Malord, let it be kept pending. We shall use our affidavit. And if the appeal is disposed, then everything.
Same interim protection to the petitioner. Let affidavit in opposition to the present application be filed within a period of 8 weeks from date. Reply thereto, if any, be filed within 2 weeks thereafter. Full stop. Within 6 weeks thereafter. Full stop. This matter shall be taken up for consideration upon disposal of the appeals being MAT 960 of 2021, MAT 1257 of 2021, and MAT 686 of 2017. Those are miscellaneous appeals.
Lordship, applicable.
One is appeal of 2017 is against the final order of Justice Chatterjee, Malord, Swampti Chatterjee. as a.
Then say so.
No, this is one appeal, but others are on against the interlocutory order of the 2021 appeal.
Say that if the finally disposed.
No, one matter was finally disposed.
Maybe, but if the issue is finally
No,
disposed.
but the order where it has been stayed, the subsequent notification, Malad is talking about the subsequent.
Oh, these are subsequent.
Yes, ma'am.
No. No.
Grateful, Lordship.
Grateful.
Hard dark, no. Hard dark.
Malad, may I take back the
Appeal to pending আছে interim order miscellaneous order passed. Evidence রেখে দাও
My lord, I'm for the petitioner.
Yes.
Respondent minister. My lord, these will be the third consecutive dates. Learned AGP fails to submit the instruction from the respondent number 3. What will be my fate? I have appeared on written examination for the post of steno on 6/8/2017.
Why his results is not been published?
And still now, I'm going.
Principal submission is that we have forwarded it all to the local body. The local body is yet to take a decision.
What would be my fate, my lord? How long I will roaming from here and there?
Today, Mr. Shah, learned additional government pleader, once again prays for an accommodation to take appropriate instructions on the matter. First of having heard the learned advocates for the respective parties, let this matter stand adjourned and appear under the same heading in the next available circuit. First up, it is made clear that no further adjournment shall be granted to the respondents.
Deeply obliged.
What is?
Police in action. I made a complaint before the police authority.
When?
Page 20, my lord. Lord.
Here's what happened.
A case already registered.
Okay, registered.
Registered and already investigation has been, non-FIR PR has been registered under section 506 and 34 of the.
Where is the FIR?
Pardon?
Copy of FIR.
Yes. Non-FIR PR, my lord. It's not FIR because it is entirely a civil dispute.
Civil dispute is clear.
No cognizable offense.
This opposite party, private respondents, my lord, enter into the land of the petitioner.
No, it is a complaint. On the basis of a complaint,
yes.
Without lodging, without registering an FIR, how can you proceed?
Well, that is under section 506. Permission has been sought for from the learned the trial court of the learned ACGM, and permission has been granted to start prosecution under section 506 of the IPC.
Show me.
Well, this is the non-FIR. These are non-cognizable cases.
The petitioner complains of inaction on the part of
Pundibadi PS.
on the part of the police authorities in failing to take cognizance. In failing to take steps on the basis of the complaint made with the petition on 26th of January 2024, forming annexure P2 to the present application. Full stop. The learned advocate representing the state respondents, Mr. Such and such, learned advocate representing the state respondents by placing before this court the report for prosecution in cases in which non-FIR reports is used. By placing before this court, a report used submits that on the basis of the petitioner's complaint, Pundibadi PS GD number 348 and 378 dated 6th March 2024 has been registered.
And sanction for prosecution has already been obtained from the concerned court.
Registered. Post of sanction for prosecution has also been obtained
from the court of the learned CJM Kuch Bihar.
From the court of the learned CJM
CGM Kuch Bihar,
Kuch Bihar under section
506-34.
under section 506/34 of the Indian Penal
Indian Penal Code.
Post of the matter is being inquired into.
Yes.
Post of let a copy of the yes.
Try to respond.
Let a copy of the aforesaid communication. Let a copy of the aforesaid report for prosecution in cases. Let a copy of the aforesaid report dated 6th March 2024 as made over by Mr. Such and such in court today be written with the record. Full stop. Mr. Rahman. Mr. Rahman. Be written with the record. Full stop. Mr. Mishra, learned advocate, enters appearance on behalf of the respondent number 528. Mr. Having regard to the submissions made by the parties and considering the materials on record, I am of the view that since the petitioner's complaint has already been registered and steps have been taken by the respondents, steps can be taken by the police authorities. No useful purpose will be served at this stage to keep the writ application pending. First of the police authorities are however directed to complete the investigation at the earliest. And it's not investigation, inquiry.
Inquiry.
Complete the inquiry at the earliest.
Yes, ma'am.
With the observation directions, the writ applications. No, bole diyechi to. Age na, just stands disposed of, there shall be no order as to cost. Peter সঙ্গে না, এইটা না, শুধু একটা পাতা। Now, Mr. Sir, where is that page? Find out for me and hand it over that particular.
Only
page.
that particular page, my lord.
You want to hand over the entire document?
Entire may be kept on record.
By placing before this court কি বলেছি? ওপরে. By placing before this court, ওইটা আছে dot আছে তো? Placing before this court পুরোটা আছে তো? কি লেখা আছে?
The report of the.
By placing before this court the report for prosecution in cases in which non-first information report is used, submits that in Pundibari case number certain. Let a copy of the aforesaid report along with a compilation of documents as made over in court today be retained with the record.
I am for the petitioner. Service not affected.
Since it is submitted, দেখি দাও। Since it is submitted on behalf of the petitioner, that service on the respondents, you are there appearing.
I am appearing for the state respondent.
Service on the private respondent or respondents?
Respondents.
Private respondent. No. Where is the private respondent? All are state.
All are states.
Then,
We have already served, but not delivered.
although it is submitted on behalf of the petitioner, that service on the private service on the respondents is not complete. However, the learned advocate, Mr. Such and such learned advocate enters appearance on behalf of the respondents, or all respondents.
Lordship.
Respondents, full stop. At this stage, Miss, what is your name?
Konika Sarkar.
At this stage, Ms. Sarkar prays for an accommodation. In view thereof, let this matter stand adjourned and appear before the next available circuit.
Yes.
At this stage, করে দেবেন, full stop, yeah? No.
16, we are appearing for respondent. CGST.
Who's for the petitioner? Yes.
Prashanto.
They file good.
No one is.
Next circuit.
Next circuit.
What is the challenge?
Challenge.
People don't want to move the matter now.
Yes. Challenge is the claim. And there is a appeal provision also. They have not preferred any appeal. Entire opportunities were given for personal here. Moreover, it is also contradictory. In their own.
Who is appearing? Yes, madam, you are there. Are you appearing?
No. Next matter.
Who is appearing? Prosenjit Das, where is Prosenjit Das? None appears for the petitioner, no accommodation has been paid for in view thereof, though no. None appears for the petitioner, no accommodation has been paid for, though Mr. Bonik, learned advocate, enters appearance on behalf of, no, though Mr. Bonik, learned advocate, representing the respondents, is present in court.
Yes,
Representing respondent is present in court, full stop. In view thereof, to provide one more opportunity to petitioner to present its case, let this matter stand adjourned and appear before the next available circuit.
next available.
No, nahi, it nahi.
I am appearing on behalf of the petitioner.
But
Yes,
I
madam.
appear, for the respondent number 7, the private respondent.
Yes, madam.
Your Lordship, this is regarding, Your Lordship, an encroachment, Your Lordship. The respondent number 7 has encroached the property of the petitioner, Your Lordship, and have constructed a boundary wall. There was erstwhile a boundary wall, but that was not at the location now where it has been constructed. We have given notice to the municipality and also the local councillor, but nothing has been done. Not only that, Your Lordship, they have also constructed a shop room connected to the wall, and all the nuisance, all the waters and things are coming into my premises. So, Your Lordship, I was
Your complaint is at page 141, madam.
Yes, Your Lordship.
Kindly check up annexure P7.
That's the complaint.
Yes.
My only
You are appearing for?
The private respondent.
Where is the municipality?
Your
Yes.
Lordship,
Municipality, my lord.
Yes, catch hold of him. Yes, yes.
Huh?
17.
Yes, Mr.
সব আছে, মেয়র, টেয়র সবাই আছে।
Yes, Mr. Municipality. Yes, you tell me, sir.
মাইকে কথা।
Appearing for the municipality. Madam, copy has not been served.
Your Lordship, it has been served, Your Lordship, by hand, Your Lordship, 125 and 67 by registered post. But the
Yes.
problem is that, Your Lordship, the advocate on record could not go to Jalpaiguri to submit that document. If Your Lordship permits, we can share screen and
Mr. Dhar, it is there. Your office is having the copy. Private respondent has been served and you will not be served is not expected. It could have been the other way around, Mr. Dhar.
No.
So, will you take steps on the basis of this?
My only prayer is that, Your Lordship.
My lord, a civil dispute, even if there is a dispute.
How will I go into this?
Yeah, that is why, my lord, writ court, in all due respect, my lord, cannot go into this.
This is not a civil dispute, Your Lordship. Without,
Allegation of encroachment into another's property, my lord.
it's an unauthorized construction.
Monday. Monday,
Your
so many matters are there.
Then Tuesday, Wednesday.
No. Friday, Friday 3:30, Mr. Dhar. You are going to Darjeeling?
তোমার তো কলকাতায়
Monday.
Your Lordship, my humble prayer is that the municipality to look into the complaint that has been made and
complaint
investigate.
of encroachment, my lord, a municipality, I ask myself, my lord. Alleged
A complaint has been made.
not said.
Whatever, municipality either looks into this or rejects this. Decision has to be made.
Your Lordship, a shop room.
I bow down to a lordship, but a writ court's jurisdiction has.
I am not going into this at all. If Mr. Dhar is ready, I will dispose it of today. But Mr. Dhar does not appear to be very keen.
Chairman, the Lordship, commissioners, we have been made a part.
Commissioner is not a party. Madam, 287, commissioner has to be considered all. You are asking relief under section 287, madam.
Your Lordship,
Where is the commissioner?
The main person is the commissioner. The mayor and chairman.
Madam, you have to add these persons parties.
Your
Who is
Lordship,
there? Advocate and record is not there. How can I grant leave? Even if
Your
I grant
Lordship,
leave, who is going?
she's online, Your Lordship.
Online, he cannot correct.
Your Lordship will kindly keep it on Tuesday so that she can go and do the correction.
Monday, Tuesday, I do not think it will be possible any further to take up these matters. Monday.
Monday.
GST মামলাটা কবে আছে? Tuesday. Monday. Since an accommodation has been sought for on behalf of the respondent number. Let 3, 4, 5 and 6. Let this matter stand adjourned and appear under the same heading on Monday. Full stop. Considering the submissions made by the parties, leave is also granted to the petitioner's advocate and record to
make the.
no. What is the name? Commissioner.
Commissioner.
To add Commissioner Siliguri Municipal Corporation as party attach Commissioner Siliguri Municipal Corporation and the Siliguri Municipal Corporation, which is a body corporate, as parties to the present application. Full stop. Let such addition be carried out by the petitioner on or before the matter is taken up next. Full stop. On or before the matter is taken up next. Full stop. Mr. Dhol, learned advocate. Mr. Dhol, learned advocate, accepts service of notice on behalf of the added respondents.
Your Lordship.
It should be added, otherwise.
Yes, Your Lordship.
No, this order shall not be uploaded till such time it is added.
Your Lordship.
Order shall not be uploaded till such time it is added, madam.
Yes, Your Lordship, but the difficulty is that the advocate on record has to go. She will go on Monday and then the correction will be done. So.
Next circuit in that case, madam.
Your Lordship, Tuesday can't be taken.
Tuesday.
But
madam, the order will not be uploaded unless the correction is effected.
Yes, Your Lordship.
Two parties, Commissioner, Siliguri Municipal Corporation with the address and first Siliguri Municipal Corporation and then the Commissioner.
And the Commissioner.
Ulto kore deben orderta Siliguri which is a body corporate and the Commissioner Siliguri will be added as parties.
Good.
Deeply obliged.
Let the aforesaid correction be carried out by the petitioner's advocate on record on or before the matter is taken up next. Please, this matter.
Your Lordship, may I in JPD 16, due to some technical issue, I am failed to appear in a similar matter to.
Do not mention. Yes. Your matter is in the next circuit. Where were you?
Your Lordship, due to
it has not been dismissed. Next circuit.
Kindly put the matter.
Your Lordship, in a similar issue today, Your Lordship has passed a decision in JPD number 3, item number 3. Your Lordship has passed similar matter exactly. JPD 3 is section 73 violation.
Where is Mr. Bonik? Yes. Mr. Bonik, you ordered which matter?
Said Mr. Bonik was there in that matter. JPD number 3, violation of section 73.
Wait, you orderটা দিলাম না? Mr. Bonik, when you want it? When I said the other matter will come up?
On Monday.
List on Monday.
Lordship, grateful. I tender my apology, Your Lordship. Due to some.
List on Monday.
Not the similar matter.
He's saying.
No, it is not the similar matter.
It is not a similar matter.
Section 73 violation. Technical challenging the jurisdiction. That is under section 73.
No, that is limitation. Same case, limitation.
Same limitation, section 73.
In this matter, limitation is not applicable.
I will dismiss the matter if it is not on limitation, sir. On the next date, make up your mind.
Your Lordship, grateful. Monday.
Let it be there. এইটা নয় অন্য
Next circuit এর জায়গায় Monday।
18 টাকা 18
Next circuit এর জায়গায় Monday হচ্ছে তো, ঠিক আছে।
18 who's appearing? Yes, madam.
For the respondent number 3. For the respondent number 3.
Kindly put this matter on Tuesday, my lordship. My seniors won't be available because.
Next circuit. As prayed for by the petitioner, list this matter. শুধু not today করে দিলি না, not this week করে দাও শুধু not this, আর কিছু না. As prayed for by the petitioner, list this matter before the next available circuit bench.
Yes, your lordship.
Nineteen and for the petition. My application under section 14 of the Service Act has been kept pending, my lord. It is at page 155. I've preferred this application on.
Kept pending?
Yes, my lord.
Kindly have a look at page 155, doesn't it?
227.
My lord, my lord.
227.
No, my lord.
Why not?
Several matters have been filed, my lord. The Supreme Court has entertained, my lord. Orders have been passed.
That is different issue. DRT.
Yes.
Go before 227. Failure to exercise jurisdiction.
But it has been kept pending, my lord. But I'm only asking for a direction to expedite the hearing, my lord. Because there is a special mandate, it has to be completed within 60 days. That has not been done, my lord.
It is the present writ application has been filed. Everyone is appearing?
Well, I'm looking for the district magistrate. He is appearing for the borrower.
You want this to be kept pending? You want the matter to be kept pending?
Yes, I'm fully praying for
Yes, I'll record it.
one, I was praying for 1 month because my client is trying his heart to settle. He's trying to settle the account with the bank. So I'm fully.
You are?
Kindly record that, man.
You are?
Man, I'm for the, secured creditor, man.
He's for the bank.
The Reliance Home Finance, my lord.
Finance company.
Finance company. If he says so, man, kindly records that.
Next available circuit, I
Man,
proceed.
kindly record that, my lord. Man, he is making an open offer, my lord. Kindly records that, man.
I'm not exercising, I don't want to exercise jurisdiction.
Man, kindly,
You know,
man.
hey,
Since
you go
2022,
before 227.
Since 2022, my lord. My lord, several writ petitions have been entertained, my lord. I
Please-
can show those.
Arey,
documents.
those, maybe
If you
these
can
are-
next on Monday, I can bring those orders, money. Several orders have been passed.
Next, go before the next available.
The application itself, my lord, is flawed. That's
Our-
why section 14 application, it is flawed.
You know?
I will not go into
No,
that.
no, my lord, the DM will look into it if it is flawed. 60 days mandate, that has not been followed.
Permission for filing application under section 14. He's seeking permission for filing application under section 14 before the day. He's seeking permission for filing the application. He has not filed the application under section.
It was 68 to 14.
What is the written in the subject?
Where is that? Where is that application?
Page number 155.
Prayer.
Well, there is no prayer. That is again more.
I'll dismiss
surprising.
it with cost on Monday, sir, Mr. Pal.
My lord,
How much cost you will pay for a change? Tell me.
my lord,
For a change.
Yes, fixed.
For a
date.
change, let
No,
the
my lord.
secured creditor put in some cost.
If you look at sees, my lord, page 160, a date was fixed. I prayed for fixation of a short date, my lord. Tell you sees. Page 160.
Forget 160, which is the application? Where is your application under section 14?
There is no application. my lord.
Show me your application under
Yes,
section
my
14. Go before the next available circuit. I think it is better, Mr. Pal. You can
My lord,
convince.
I shall file a supplementary.
You know, yes, you can convince. Yes. Learned advocate representing the petitioner seeks leave to file a supplementary affidavit. Full stop, without going into the question of maintaining the application. At this stage, leave is granted to the petitioner to file supplementary affidavit. Let the supplementary affidavit be filed. Honor before the matter is taken up next. List the matter before the next honor before the matter is taken up next, with an advance copy thereof to the learned advocate representing the contesting respondents. No, all respondents. Full stop. List this matter before the next available circuit bench. No application, Mr. Pal.
No application as of.
There must be, I'll bring it.
That's why I recorded without going to the question of maintainability. Yes?
Evidence will be taken up.
ওপরে দিয়ে দাও একটু। I have indicated that without going into question of maintainability, you can argue that point. At least it will be dismissed without cost. He'll be happy that I accept. Call the next matter.
Lordship, and for the petitioner, Lordship, the conducting counsel will be appearing on a virtual mode.
I represent the respondent numbers 1 to 4.
Maybe connection issues, Lordship. इसकी शाहजहां नाली इसकी शाहजहां नाली
Yes. Next circuit.
One day accommodation, Lordship.
Tomorrow.
Next week.
Tomorrow.
Tomorrow there is a problem.
Fine.
I had to go to the Kasma.
Darjeeling.
Kalimpong.
Whatever.
Next week, any day, Lordship.
In 2 weeks of circuit, if you lose the first week, what remains in the second week? Second week is only all matters to the next circuit. It's not well. Effective except for the matters which are fixed, everything will go to the next circuit.
This matter can be heard. The representation may be considered.
In accordance with law.
As per and in accordance with law.
They are seeking for the higher scale of scale.
They are seeking for higher pay scale. Their representation is in page number
I am not
31
in favor of granting directions for consideration unless she is in a position to establish a legal right. You are aware. You will move it.
No, Lordship. Actually, I don't have any other instruction, Lordship.
I read the brief.
No, Lordship. I just.
Why did you come to court without reading the brief?
Lordship, I'm not the conducting counsel.
Does not matter. You are holding the brief on behalf of your senior.
No, he is not my senior. He just instructed me to appear and pray for time.
That's okay.
He knows.
Not this week.
Grateful.
21.
আর কোনো মামলা অ্যাড করবে না, ঠিক আছে, যতক্ষণ এগুলো শেষ হচ্ছে। কম্পিউটার ফাইল ছাড়া এখন কোনো মামলা অ্যাড হবে না, হিয়ারিংও অ্যাড হবে না, কিচ্ছু না। আজকে যা দিয়েছে হাতে রেখে দাও। হ্যাঁ, কোনো অ্যাড হবে না, কেননা তাহলে আমি শেষ না করতে পারলে নেবো না। এতদিন নেয়নি, আর সামনে সপ্তাহ দিয়ে কি হবে? ফার্স্ট উইক চলে গেল, যা আছে আছে, হোক। আর দিয়ে দেবে, তুমি মেনশন।
Lordship, praying for not today. Lordship.
Are you there in the matter?
No, Lordship.
I will not hear you.
Lordship, the conducting counsel had to leave court today itself. He was present, but some urgency he had to leave. Lordship.
What is the matter? What is the matter?
Police in action, already charge sheet has been filed. If they are eligible, they can go before the concerned court. There are cases of police in action, already matter has been inquired, accused has been arrested, charge sheet has been filed. Nothing new.
Lordship, I don't have any instruction, Lordship.
Not today.
Kindly then sort Passover, Lordship.
Passover. হ্যাঁ, ও তো Passover. Ascertain, I'll dispose it off.
Lordship,
Nothing remains in these matters. What for you will retain these matters on the file? Go read the brief and come. Yes, call the next matter.
22.
Wait here. Because next week all these matters are being piled up unnecessarily. You are not ready with the matters. Yes.
The issue is this: the petitioner is a school teacher who has served in a particular school for more than 20 years, and he is service transferred to his nearby.
পরে থাকা অন্য জজ সাহেব ফ্লাওয়ার বলবে লাগাতে। Yes.
Actually, the petitioner is a school teacher who is posted in a particular district away from his home, Lordship, there he has served more than 20 years of his service without any break. Subsequently, she is suffering from some unavoidable circumstances, and she paid for transfer of the service to his nearby home or home district or any adjacent home district. Lordship, his transfer application has duly been applied in USOC portal, and that has been registered. But this and it is found that the one particular post is vacant initially at his nearby the district, but when the writ application is being filed, that particular post has been filled up, but in the nearby district, a similar post has been lying vacant. She may be transferred. This transfer application has not been decided. So this is the.
Where is your transfer application?
I have filed the transfer application through online on 89. Yes. 89. It has been registered. The next page 90 is it has been auto-generated registration number. My application is at page 89, and subsequently page 90 indicates my registration number of my application.
What happened thereafter?
Subsequently, no decision has been taken out. Taken and communicated. Now,
yes, sir.
Pending the SSC.
Pending before the SSC. So you are the commissioner. Commissioner has made recommendation. Where is the commissioner? Where is the commissioner? Not a party? Yes, sir.
party, yes, the board, regional school service commission, Northern region, respondent number 3.
Respondent number 3 is the commission.
Yes.
Who will make the recommendation? Recommendation is to be made by the.
This is the auto-generated process.
Very well. Recommendation has to be made.
They will take out.
No, recommendation has to be made by the commissioner.
So they will.
Add commissioner as a party. Add commissioner as a party. Here and now. You are the advocate record?
Yes.
Yes, very well. Leave granted to add the commissioner, school service commission. No, commissioner, school service commission only. Yes. And yes, and Mr. Rai appears for. No, the Rai appears for number 3, West Bengal School Service Commission. And this recommendation has to be. Mr. Lahiri's order লিখিত আছে তো একটা ওই আগের দিন সেটা দিলাম একটা ফাইল আছে সামনে দেখো তো ফাইলটা দাও না একটা ফাইল যে কোনো একটা ফাইল দাও না The commissioner will take the decision. Commissioner has to take the decision. And that decision, after the commissioner takes the decision, the effect thereof will be given by the commission on the basis of the recommendation to be made by the commissioner. Let leave granted to the petitioner upon hearing the parties. Leave is granted to the petitioner's advocate and record to add the commissioner of school education, West Bengal, having its office at Bikash Bhavan, Bidhannagar, Salt Lake City, Kolkata 7,91,000, to be added as a party to the present writ petition. Post of the present writ application has been filed, inter alia praying for a direction upon the respondent. Number 2. Internally, you are praying for a direction upon the concerned respondent to take, to dispose of the petitioner's transfer application dated 7th September 2022. Full stop. The petitioner is a where have you said that the petitioner and assistant teacher, which paragraph?
At paragraph number.
The petitioner stated that it is Mr. Successor Learned Advocate representing petitioner submits that the petitioner is an assistant teacher and is assistant teacher in where is the school?
Macmillan High School. Macmillan High School. Paragraph number 4.
And at present is imparting education to the students of McWilliam High School at Alipurduar. Full stop. It is the petitioner's case that inasmuch as the petitioner has completed the mandatory period of 5 years of service, the petitioner had applied for transfer in terms of the West Bengal School Service Commission within bracket general transfer, comma, transfer on special grounds and reallocation bracket close rules 2015 hereinafter referred to as the said rules. By referring to the application at page 89 of the aforesaid writ application, at page 89 of the aforesaid writ application and the printout from the Usosri portal of the respondent number 3 as appearing at page 90 of the writ petition, it is submitted that although the petitioner's application had been registered on the online portal platform of the respondent number 3, no steps has been taken by the respondents to dispose of the petitioner's application for transfer. First of the petitioner, in terms of the petitioner has a legal right transfer. First of the respondents are sitting tight of the matter. No steps has been taken by the respondents to dispose of the petitioner's application for transfer. First of the respondents are in fact sitting tight over the matter, and unless this court directs the respondents, directs the respondent number 2, directs the added respondent, directs the commissioner, West Bengal School Service Commission, to dispose of the petitioner's application, comma, the petitioner shall suffer irreparable loss, injury, and prejudice. Paragraph. You are appearing for? Learned Advocate enters appearance on behalf of the respondent number 2. While Mr. Blank, Learned Advocate, enters appearance on behalf of the
State.
Respondent number 1. None appears on behalf of the respondent number, none appears. School Service Commission, none however appears on behalf of the West Bengal. Am you adding them a party? Mr. Roy is not there.
Because he has made regional food service commission a part.
প্রথম লাইনটা করে ছেড়ে দিয়ে সোমবার দিয়ে দিন, সোমবার নয় বুধবার দিয়ে দিন, বুধবার The petitioner is directed to ওইটা হলো add হলো petitioner is directed to effectuate effect service of the present application on the added respondent. First of leave is ওখানে উপরে না, ওই প্রথমে আগে পড়ে দিন তো জায়গাটা ঠিক ছিল। as also the West Bengal Central School Service Commission service through the chairman having its address at Acharya Sadon, EE 11 and 11/1 block, sector 2, Salt Lake City, Bidhannagar, Kolkata 7,91,000 as parties to the present proceedings. Let such addition of party be carried out. In course of the day, the petitioner is directed to serve notice on the added respondents. Next circuit.
No, next.
You can't come. Unless Mr. Roy comes, I will not take it.
I will inform Mr. Roy over phone also. Meanwhile, I am serving the copy.
Petitioner is directed to effect service on the added respondents. Full stop. List this matter for further consideration on blank on Wednesday. Prepare affidavit of service and legality. এটাকে সরিয়ে দাও, এটাকে দিয়ে দাও। আজই অ্যাড করে এক্ষুনি দেবে। Check up this file also, you'll get the name of the respondents you need to add. Because the order will come later, you'll get from this file. ওটা ফেরত দিয়ে ফাইলটাকে তুলে দিও জায়গায়। ওনাকে দেখতে দাও, তাহলে অসুবিধা হবে ওনার। The commissioner and the commission both. First the commissioner and then the commission both should be added. Sir, that is a disposal of matter. Kindly be careful. Yes. The other matter is already disposed of matter, so be careful while disposing. Yes. We call the next matter. No. বুধবার আসবে। ট্রান্সফার অ্যাপ্লিকেশন করে দিয়ে দেবেন। Same matter? No. Sir, Regional Service Commission will not help. They have no power.
You will only forward.
Yes.
So the issue is this, Lordship. The respondent had quoted a recruitment notice for the retired employee for the post of
What interim order are you seeking?
interim order, Lordship.
This cannot be disposed of without calling for affidavit.
It can be disposed of. It's a simple matter. Why I'm telling Lordship, which is everything is on the record.
I'm yet to receive my instructions. I have only had a word with the official.
Lordship, let me submit my case, then.
If you don't want them to file affidavit, then you don't want to have them instructions, have them obtain instructions in the matter. How is it possible? Either then I'll issue direction for filing of affidavits. Make up your mind. Second option. So let them take instructions and come back. I'll pay it in the next circuit.
Yes, madam.
Actually, taking instructions in the matter.
The problem is just, otherwise the appointment will be given. The pure illegal the underage, the issue is very simple. Underage incumbent has applied for the post and he has not even qualified to apply, but he has been given an appointment.
Appointment has already been given.
Issued, but not joined. That has been challenged.
How do I know?
It is conspicuous on the record itself. That's why I'm paying.
Where is the private respondent?
Private respondent is respondent number 8. Private respondent number 8. Kindly see.
Wednesday. Take instructions. Can you take instructions by Wednesday?
I'll try my best, but I don't want to upset the lad. I'll try to take instructions by Wednesday and I'll try my best, but I cannot assure that is the thing. Because obviously I always okay.
Since an accommodation has been sought for on behalf of the respondent numbers.
What state respondents?
On behalf of the respondent numbers 212.
127,
126.
1261.
Let this matter stand adjourned and appear under the same heading on Wednesday next.
1 to 6. Grateful.
Item number 24. Petition before lawsuit saying a legal aid certificate from municipality because of we have made representation and even after that we do not.
Legally a certificate.
Yes, the certificate issued by the
Legally a certificate.
certificate municipality.
Why will the municipality issue a legal aid certificate? How is it competent?
Certificate that issued by the municipality.
What certificate? It will be a decision in rem.
But the certificate that issued by the
What is the nature?
the husband of the petitioner was the died Miller. After that
Death certificate.
death certificate has been issued Miller. After Miller we have applied Miller, me and my daughter applied for the Miller certificate from municipality as a legal aid Miller.
How is the municipality competent? How is the municipality competent? Show me the provision. Yes, Mr. Rai, municipality can issue certificates nowadays. So, how is the municipality competent? Take back your petition, file afresh. Take back your petition, file afresh. Municipality is not competent. They are not parties. Take back your petition, file afresh. Because you have to proceed on the basis. No demand justice is also there.
Made representation.
To whom? You want me to dismiss the application? To whom? Demand justice to whom?
Chairman of the municipality. Chairman Miller as well as the
Sir, take instruction in the matter. This is not maintainable. File afresh. I'll grant you leave. Because there is no letter addressed to the concerned authority. Municipality cannot issue this. Not competent in law. Unless they are very generous, they want to assist you.
Petition is not required. Let them apply, they will get.
Apply before the court, obtain a succession certificate, letters of administration.
No, legal aid certificate, the authority.
That is different. Municipality has no power. Yes, tell me what you want.
Certificate.
Nowadays, municipality is doing everything. Everything.
On the basis of affidavit sold by the party.
No.
They are issuing certificate. No. On the basis of.
Show me a power of the municipality to issue certificate. Learned advocate for the petitioner seeks leave to withdraw the aforesaid application with liberty to file afresh on the self-same cause of action. Now, learned advocate representing the petitioner submits that there are formal defects in the aforesaid application, and as such, he seeks leave to withdraw the aforesaid application with liberty to file afresh. Full stop. The learned advocate representing the state respondents does not oppose to such prayer. Full stop. Having regard to the aforesaid, leave is granted to the petitioner to withdraw the aforesaid application and file afresh on the self-same cause of action. Formal defect, formal defect. আর কত আছে মশান? হিয়ারিং যাবে না?
26.
My lords, item number 26, I appear for the petitioner, my lords.
I am for respondent number 2.
May I start, my lords? My lords, I am audible. Am I audible, my lords?
Yes.
My lords, this is the second round of litigation, my lords. My lords, what happened here is that at the time of filing my return, GSTR 3B, for the month of September 2017, an inadvertent error occurred due to my accountant, as a result of which input tax credit to the tune of ₹4 lakh was claimed less than the actual amount, my lords. To rectify that mistake, my lords, what my accountant did for the subsequent month, that is, sorry, my lords, first was September. So September, there was a mistake.
Mr. Monik, input tax credit matter is coming up when, Mr. Monik?
My lord,
The input tax, this same similar matter is coming up when? On the first or second move?
similar matter
On Tuesday.
Tuesday. Moreover, my lord, just yesterday I have received the brief. Just yesterday. I have to take the instruction.
Why have you not served the brief earlier?
My
Petition.
lords, no, my lords, it was served on 22nd
22nd.
to the department.
Then, no, no.
22nd to the DSG office.
Department. Yes, lordships, yes.
Then I'll place it next circuit. Then I'll
This
place
is
it
not
there.
this is not an urgent matter, my lords. Next item is also mine, my lords. That I'll press because that is urgent, more urgent, my lords.
Since the learned advocate for the respondent submits that he requires Mr. Monik, learned advocate, enters appearance on behalf of the respondent numbers, on behalf of the respondent number 2, full stop, while Mr. Sanjay, learned advocate, enters appearance on behalf of the respondent number 1, full stop. Mr. Monik prays for an accommodation to take appropriate instructions in the matter. First of having regard to the aforesaid, let this matter stand adjourned and appear under the same heading in the same heading before the next available circuit.
Grateful.
But please serve the other side in advance.
My
These are
lords.
GST matters. Will they assist the court? Yes.
I'm sorry, my lord.
Very well. Next matter.
My lords, I am appearing for the petitioner.
Dako.
My lords, I have the survey of affidavit with me. If my lords wants, I can share that PDF copy, my lords. It was served on 18th
Just a minute.
April.
Just a minute. Yes. Kindly speak on the microphone, otherwise gentlemen will not be able to hear you.
My lord, Mr. D.K. Agarwal, Dilip Kumar Agarwal is appearing on behalf of the state in this matter. His health is not well, he has not come to court, my lord, today, only not today.
My lords, I am aware of this, my lords, but I'll press that this matter be heard next week because my car is standing seizure, my lords, till date. That is the urgency, my lords. It was a second-hand car, 12-year-old car. I am a company, my lords. I was transferring this car to my employee. This was not a supply, my lords, but they calculate my tax and they charge penalty, my lords.
Under the provisions of
129, my lords, of the CGST Act, my lords.
Yes. What is the vehicle?
My lords, it's a second-hand Duster car, my lords. 12-year-old second-hand car, my lords. I am coming against the appeal order, my lords. The appeal order is at page number 126, my lords. Starts from page number 126.
You consider and dispose of his representation. Then
My
only
lords, first they passed the detention and penalty order, my lords. I filed an appeal. My appeal was dismissed, my lords. Now, my lords, in this case, there is no disputed facts, my lords. They have admitted that it is a non-taxable item. But what they are saying that is not relevant. My lords, I'll satisfy from the act itself, my lords. Kindly see section 129, my lords, for a moment.
One day's accommodation, kindly give.
I will grant you accommodation. I'm trying to understand. Why are you anxious? I'll not pass any order against you without hearing you. Yes.
My lords, kindly take section 129, my lords. Without getting into the facts, my lords, I'll show you the law, my lords. Notwithstanding anything contained in this act, where any person transports any goods or stores any goods while they are in transit, in contravention to the provisions of this act or rules made thereunder, all such goods and conveyance used as a means of transport for conveying the said goods and documents relating to such goods and conveyance shall be liable for detention
or seizure, and after detention or seizure shall be released, clause number A, my lords, on payment of penalty equal to 200% of the tax payable on such goods. And in case of exempted goods, on payment of an amount equal to 2% of the value or 25,000, whichever is less, where the owner comes up for payment of penalty. My lords, my case is that even if considering their case at face value, because admittedly there was no e-way bill along with the said vehicle, my lords, when it was intercepted. So even if 129 is applicable, my lords, it cannot be more than 25,000 because tax payable is 0 here, my lords.
Yes, sir.
And my lords, one more point I want to state, my lords, kindly take section 122.14, my lords.
Yes.
It states that where a taxable person who transports any taxable value without the cover of documents.
Did you apply for release? You preferred an appeal. You did not apply for release, sir.
My lords, for releasing my
appeal. Trying to understand factually. Did you apply for release? No.
No, my lords.
Very well.
No, I did not apply.
Come on, when you want it,
Monday. Tomorrow is the election. He comes from Siliguri. Mr.
Monday. List on
Grateful, my lord.
On the prayer of the learned advocate representing the state respondents, list this matter on Monday.
Oblige.
Monday next.
I'm grateful, my lord.
So item number 28. May I please, your lordship?
28.
And for the petitioner, your lordship, am I audible?
Yes.
Yes, your lordship, this is a matter with regard to election of All India Scheduled Caste and Scheduled Tribe Railways Association. Your lordship, the petitioner admittedly has been selected as the candidate of a divisional treasurer. Now the bylaw says that once a person is elected in a post, he will hold the post for 3 years.
Where is
now,
well, this is
your lordship, we have already served, your lordship, the affidavit of services.
Nobody is there. Nobody is there.
23rd of April, they have already received.
I'm not answering.
He is the only, your lordship, the answering respondent.
Union of India.
In view of the fact that the Employees Association fall within that association.
Union of India.
No, Lordship.
Yes, your lordship. The Ministry of Railways, the association falls within the.
Wait, sir. Union of India is the answering respondent.
No, Ministry of Railways falling with the Union of India. Because the association directly is controlled by the Ministry of Railways. Where I have been appointed as a division.
Ministry of Railways is a party.
Lordship, the Union of General Manager is the party. General Manager is the answering authority. General Manager is the main answering authority because he is the responsibility to hold the election. He has the responsibility and to circulate the list.
You are the answering respondent, sir.
No, Lordship. I'm only respondent of
Union of India represented through service through General Manager.
No.
Your Lordship, I will show that all the.
Are you representing one?
Only one.
Kindly read the cost item. Kindly go through the cost item.
All this circulation of the elected committee has been made by the General Manager only.
Or is there any scope for grant of interim order?
Yes, Your Lordship, there is a scope. Why I tell you?
What do you want? What interim order?
Lordship, what I want is that even though I've been appointed in the post of a divisional treasurer and that is valid from 2022 till 2025, in the meantime, they have already holding elections for appointment of a new committee. Even though the bylaw says that once I've been appointed, I will be holding the office for 3 years. So that will come to an only in October 2025. But they have issued a notification by which they are trying to hold a new meeting.
Let them hold a new meeting.
No, Your Lordship, what they have done during the pendency of the writ petition after service, meeting has been held and the new committee has been circulated.
New committee a party. Have you made the new committee a party?
No, new committee I have not made a party because I have come to know only after filing. filing of the writ petition. Lordship, the officers who have held the committee are already made parties.
No,
After pass. Lordship, interim order, what I want is let them restrain from
The
holding
committee,
the office.
unless the committee is added as a party, how can I consider? Their interest will be affected.
Lordship, I will add them a party. I will add them a party, but in the meantime, till the next date of hearing, let the new committee not take the charge of the office.
No, how can I pass an
Not
order
take the
against
charge.
someone who is not even a party?
Lordship,
You're inviting me to this
No,
court to pass an order against a person who is not a party. Can I appreciate the situation?
I understand that. I understand that.
You add
But
him a
also
party.
this has been done after the filing of the writ.
File a supplementary affidavit, serve him and come.
Lordship, in the meantime, they will be holding the office.
Maybe.
When I am already an appointed candidate. This is against the
Your
bylaw.
right will remain. It's sub judice. What special? What will happen if they take a decision in the matter? The decision will be without jurisdiction.
Yes, Your Lordship, but the only the fact which I am aggrieved is that the
No,
bylaw says that they have
since the new
circulated.
committee has come up, I cannot take any.
Lordship, the new committee has not been circulated. The bylaw says that only after the circulation is made, then the new committee will
Serve
take
the new
charge.
committee and come back.
We will serve, but the circulation has not been done. So their new committee has still not taken the charge of the office. So
Yes,
let the
sir.
election result be not be given effect till the meantime.
No. Election
Not be-
result has already been published. How can I stop it?
No publication has not been made. Without circulation, publication cannot be made. That is the bylaw. I will show the
Status quo
bylaw.
anti-order cannot be passed. You are asking for a status quo anti-order, which has happened. I cannot alter that position unless I finally hear out your matter.
Yes, I appreciate what Your Lordship predicament
They
is
are
there,
not
but
party.
what I'm
You
trying
want an
to
order against them.
no, what Your Lordship is the fact is that the bylaws, if I show once the bylaws, it says that without circulation, the new committee will not take charge. Now that
Serve the new
circulation has
committee and
not
come
been
back.
made as per the bylaw.
Serve them and come back. Unless you serve them, I will not.
In the
pass.
meantime,
Serve them and come back.
Your Lordship, in the meantime, when
Whatever you do,
circulation is given
without
effect,
serving
then the
a
new
party,
committee will
I
take
will not
charge.
pass any order. Make up your mind. Otherwise, I'll direct exchange of affidavits because I'll record the fact that without service, I'm not interested to pass any interim order in their favor.
Then Your Lordship will kindly keep the matter in the same circuit bench. I will serve and come back in the meantime.
Whatever
Shortest
you want
possible
to-
date may be given. Next date of hearing, Your Lordship, but kindly don't send the matter to the next circuit bench. Otherwise, this will become infructuous. This entire process, because the new committee has been appointed in violation of the bylaws. I will serve the new committee. I will file a supplementary affidavit, but kindly give me the shortest possible time
I'm
so
not
that it can be heard
permitting
by
you
the
to
next.
I'm not permitting you to serve it by supplementary affidavit. It is for you to take steps in the matter, whichever way.
I
you
will do
want.
that. I will do that. I will take steps. But Your Lordship will grant me shortest possible time and don't send it to the circuit way, next circuit way, because otherwise this will become infructuous. Your Lordship, a committee appointed in the teeth when the writ petition was pending in
Why
violation
will
of
it
the
become infructuous? If it is without jurisdiction, everything will be set aside. Why will
Correct,
it
Your
become
Lordship.
infructuous? You have
No, it has
filed
not
a
become.
application. Today service is not complete. If I say it taken up on Monday, election is going on here tomorrow, nothing will happen.
Your Lordship,
Nothing.
next Thursday or Friday, by next week, any date, we will take steps and come back. We will satisfy Your Lordship that this service is complete.
Service and complete, Lordship, in the meantime, Lordship.
And if they are not even party, you have to add him as a party. You have to take steps. Where is your
By
application?
way of supplementary affidavit, Lordship.
Your
No,
Lordship, we will
supplementary
add.
I'm not granting you leave.
No, Your Lordship, we will add them as a
Take out
party.
an
But
application. Take out an application for addition of party. Take out an application for addition of party.
I will make an application.
Yes,
I will make an application.
consider it. Not today. File it immediately. And
Lordship.
I will do that. I will do that.
you ought to have moved. You have taken care of the situation.
Your Lordship, what has happened? This has been done in the last week of 24th of April. So we could not have taken steps. 24th of April, this new committee has been appointed.
Very well.
And today is 25th, just one day before. One day before this has happened. So that's why we put it.
Sir, on oral prayer, I will not entertain your oral prayer and grant any relief without them being a party. Why are you insisting for granting relief on oral prayer?
No, I will make the, if your lordship, I will make them a party,
Whatever
but
you want
kindly,
to take steps.
but kindly keep it in the next thing, your lordship. But if the matter is sent to the next circuit bench, then it will, there will be a
I'm
delay,
making
your
it
lordship.
not today. You have to take out an application. The application has to be moved. Party has to be
Yes.
added. Come back on the next. Whenever you come back, I'll take it up.
Grateful.
I for the petition. This is my evidence
নন
service.
স্পিক করে দিন ওটাকে নট টুডে করে রাখুন তারপর দেখা যাবে
All privates are accepted. One except one refused. All are brothers.
you are for
I'm statement.
state
I have served legal private as well. I said what happened, my lord. Judgment to follow. Service go.
what is the matter what are you praying
I say, the matter of requisition, acquisition, and awarding of award to somebody else. I just place the fact of the case, my lord.
same point
This no, here, my lord, award was given somebody else. That yesterday, doing this petition. I said, what happened, my lord? The predecessor of the petitioners was the recorded owner of the
no
property.
award where is the award
Award given to somebody else. I show from the documents. Section 48 Act. I place it, but
48 act 1
there's no section 3 notice to me. No notice under section 4 to me. Award was given somebody else.
In the year 1983, there
was there a notice under section 4
No, notice not to me, not to me.
no act 2
They should give me.
act 2 notice under section 3 was there
No.
what are you saying without notice under
I just place it, man. I just, my lord, this I covered with three, I brought a judgment also. I just place it. What happened? So my
you have been given a new lease of life by an order passed by the court already
yes, yes. Not only that, my lord, this order is a collector's order.
you're challenging that LA collector's order
I challenge the collector's order and
no you're challenging this order passed by the LA collector
no, I know.
special renegociation collector
Yes.
this is a subject matter of challenge
Yes.
what interim order are you seeking
No, let me give one.
then Mr. Rai you got a lease of life by that previous order
No, not only that, my lord, this is very, I told that, I'm also, but now I got this judgment, my lord, or high court, when it can be revived. You know, this evidence is required. And see, they should bring the section 3 notice, 4 notice, and my lord.
everything will happen after the affidavits, not now.
Then you understand, I served, I went the private parties also, served them. Only one is refused, my lord. Again, the
The
demand of
petitioner
justice.
challenges, the petitioner challenges.
If my lord is
I'm
valid,
I'm asking
let
for.
the maintainability point be also kept open, my lord. I'm saying that the writ court cannot exercise jurisdiction and
That-
go to the.
Well, what were you doing when previous coordinate bench passed the order? Have you challenged that order?
No, for the consideration of by the special LAO, the special.
No, you finished.
Yes,
Once you permit that, now the
Special LAO?
order passed by the special A can always be challenged.
Yes,
Why this court cannot take up the challenge to order passed by special A?
they're not challenging that. What is the prayer, my lord? Go to the prayer once.
He is, after all, he's not challenging the order.
No, the cause of action has come from
He's not
there.
challenging the order.
No, I know, I'm trying to.
He's challenging the compensation paid to the
Yes,
respondent.
can you allow me? Cause of action come from this.
He's not saying that
order.
order is to-
So, I just place it, then my lord, an animal can reply. LA collector says order was given to somebody else. Then I came to know RTI letters. I came to it was given to somebody else. Then I say, so I started disciplinary proceedings against the person concerned, criminal case, and face proceedings regarding payment.
It's too late in the day.
No, my lord, this is after I placed 2 judgments, Tikaram and 2022.
A final hearing, you place whatever you want, not now.
No, no,
Prayer
then
is
you
my
say,
lord,
date
they're
was-
not
kindly
challenging the
ask-
order. They're saying that the compensation was to be paid.
Then can you allow me the argue?
Then let it
Or-
be.
How will you argue it today?
No.
Final hearing.
No, he's saying, so evidence is required and they'll bring the documents, the records, my lord. Can you answer why-
Fine. First, let them file their affidavit, subject to the point of maintainability of
Yes,
the-
yes, yes.
being kept open, subject to the point of maintainability of this application being kept open. Now, considering the nature of challenge involved, I'm of the view, the present writ application cannot be decided without calling for affidavits. Let affidavit in opposition to the present application be filed. within filed within a period of 8 weeks from date, reply if any there to be filed within 2 weeks
weeks.
thereafter. Full stop.
I give it the private,
The
non-acting
point of
respondents.
maintainability as point of maintainability দরকার নেই। You can always argue that.
My lord,
They are
non-
not challenged.
What is the point of maintainability?
Show this is, I have covered my judgments,
If
my
you
lord.
agreed by compensation paid to other respondent under Requisition Acquisition Act, that has to go to the reference. That period has also lapsed.
No, I'll show it, I'll show you.
That
I'm
they
covered-
can show, but let me put my affidavit.
The reference is for what?
This is the reference.
They are challenging the compensation paid to the respondent.
Section 18 reference for what? Enhancement of compensation.
Yes, my lord. If they agreed by any compensation paid.
I'm
to
not
the-
agreeing with the compensation, I'm
No.
in the procedure.
That is their prayer. They are saying that they agreed by the I paid to the other respondent.
Yes, this is.
They are not challenging. the
Yeah,
order. My order is not-
my
they are
point
not
is that
challenging the
you have
status
not-
of my order of the special LO.
I'm not, oh no, well.
দেখো, না, না, দেখি। Show me the judgment, I'll decide it now.
I just please,
Show me the judgment.
But this is our High Court judgment. What happened, I just say the facts.
No, show me the judgment.
Basically, take it, then copy it. This is one of two on the limitation one.
The citation by copy.
And it's not the issue. But you're also gonna, I'm going to place them and I just place them and it's a really interesting points are there, but.
2024, you want to reopen proceedings like this?
But if you're assuming that, this is this is a High Court says. But they are you have to make the award afresh. If there's a latches on, this is 22.
What latches?
Because they.
What latches? Why are you sleeping
Section-
over your rights?
Section.
Why are you sleeping over your rights?
But
What
this
is the
this all-
delay?
This is also because of 22, they can reply to the Supreme Court.
Which paragraph? Which paragraph?
Which one, Michael? You lost it.
You handed over before Justice Bose, Division Bench, Kolkata.
I just, this is judgment. What happened, Michael, here, I just place the fact of the case. In this judgment, what happened?
Yes.
This is toward the one point of limitation, Michael. You lost it subject to loss of correction, Michael.
Yes.
So kindly, I just read now, they will file the video, they are giving the judgments, it's like decided on Monday, they are subject the judgment, they will read it. But these judgments are covered by these judgments. If you also I'm pressing, I am ready. But you also kindly come to my lord.
When was the requisition notice issued?
But I have to take instructions given. The matter was served to us.
Then you do not know.
That's what I say. Yes, some
If you are unaware of all this, then no point.
No, requisition proceedings payment was made in 1983. Compensation paid.
I'm asking you, when was the requisition notice issued?
That I have to take instruction. Like
There
from
is
the
no-
documents like
there
that.
was-
We don't get time to take instruction. They were served on. When was it served? Matter was served
I'm not
day before
trying to
yesterday.
curious anything. What I'm trying to say, when the collector passed the intermediately our High Court's order that it was under the 1940 Act was acquisition was made and compensation was given to some.
Where is the allegations of fraud, particulars of fraud?
Yes, I said.
Which paragraph?
I said.
Which paragraph?
My lord, this is my paragraph, all summation of paragraphs I've taken.
What were you doing for all these years? Forgotten about your property?
No, my lord. What happened, my lord? Currently, we are in Gujarat. Petitions. They show that the names are in the record of rights. These are legal years. In the LR record also, my name is there. And it is in the shown the permissive position to the market committee. Then they wrote the letter to the requisition authority. They kept silent. Then we went to the High Court. The High Court, my lord, this our passed an order to ask the bailiff to give a report. Bailiff has given a report here. Yes, land is with us, recorded in our name in the KB also. Then Justice Sinha was pleased to direct the collector to pass an order. Is it a pass an order?
Gave you a fresh lease of life.
Yes, yes. But now our High Court decided if there's a illegality, the evidence, this is also responsibility of the part.
You show me that you are not aware of this.
My
You have
lord-
disclosed everything. You have disclosed annexure P8.
Yes, but because this is on the order, from the order I came to know. That it was
From where
acquired.
did you, where have you stated? Where have you stated you have come to learn only recently?
Yes, that is that.
How did you get these annexures?
RTI. RTI, man. I said everything. You can see idea. If you my all, I can see the 9B. I said I given this all headings. Procedure before the illegal collectors.
What is your title to this property?
This is my I have a title.
What, show me? Show me now.
As the owners.
Show me. Which page?
This is not with me. I can bring it.
Have we not disclosed that?
No, I said reported. But because we are the legal years.
Where? Where is your name recorded?
My predecessor name is recorded.
Where?
31.
Yes.
31A.
Yes, I can't read the paper.
But it said Raju Ramkumar Maheshwari. My predecessor, our predecessor.
Where?
Page 31, Ramkumar Maheshwari. Page 31 and 31A, my lord. Can see.
What is this Form 1? What is this document?
This is record of rights, my lord. This is RS record of rights. RS record of rights, my lord. This is my land. Charcoal, Bidhimothe, Dakhali, Satto. This is an RS record of rights, my lord. It is in the name of my predecessor. The LR record also in my name.
Where is the original document?
Which one? This one?
Yes, I can't read this.
My can you can the report of the I'm showing my it will be I think you can the 34, the report of the BLR person, the order of this on High Court. Can you come to page 34? I just read it. Because when I filed the earlier writ petition, on High Court was supposed to direct the BLR to submit the report. The report. On going through the chronological order of recording status of the suit plot starting from RS, it shows RS version number.
Kindly come to page 31A.
Yes.
Kindly read what is there.
31, but is it 31A? Is a 8.
অত্ত সত্ত্বের বিবরণ ও দখলকার.
Yes.
Please read it.
This is on Borga. This is on Borga. Like I said, our predecessor.
Kindly read it. What is there?
When you can come to first page. This is the record.
31A. Read it.
Number 823 is the subject plot. The man record is Dohala. Odhiganto Mahapando Rai, some my lord, he's in Borga, in my land. These are reports 434.60 acres of land, 232 brothers, sir.
31A you are reading?
Yes, yes. So, my lord, this is a land in the name of our predecessor, and there's a Borga is there. Then you also kindly come.
Where is the number of the plot?
823. RS plot 823.
Where do I get it?
This is, my lord, that number is there. 823.
31A.
Yes. So when you lost 31A, this is a record, starter record of rights. Here the Khotiani was given, and this is in the name of Ramkumar Maheshwari.
On the left hand side, you see the DAG number is there.
No.
Absolutely.
Next page, next page.
On this page also the DAG number is there. But the column where the DAG number is there, plot number is there, can't be read because you did not get it Xerox properly.
No. When you look in the first page cannot be a plot number will be.
These are handwritten documents, sir.
Where
is the document?
Can you say, excuse me. Well, this is record rights will be. But this is not the record of rights. My lord, BLR has given the certificate recently. Can you come to page 30? Can you come to my lord? Your loss is not question RS record right, record, there's no question. I bring the can you see the report, my lord, page 34. Recent report was given by the High Court.
Show me why are you jumping, Mr. Rai? Let us understand one by one, Mr. Rai.
Sorry, I said.
Mr. Rai, you are a senior person, quite senior. Mr. Rai, you see,
Sorry,
let us proceed one by one. Annexure P1, page 31A. What is this document? This is a record of rights.
This is a arrest.
This is revisional survey. Record of
Under
rights.
1953 Act, this arrest recorders original estate acquisition act. This land has been settled with the Maishari, the 53 Act. So, the name, the name
From
of.
where do I get it that this is a finally published record of rights under the 53 Act?
This is.
Where is that stamp?
This is, and see, Form 1.
Form 1, sir. Form 1 is also under Bengal tenancy. Form 1 is also there.
CS record. Here, my lord.
Same Form 1 was used for a long time.
This is here, my lord.
Show me from this. Show me from this.
This is arrest.
Jila on the top. Jalpaiguri.
Jalpaiguri.
Mauja. Jail number 223. Khotiar number 53/7.
So revenue 784, policy number 85. Now, my lord, can come to the office of the report on the whole. 50 number, Koite, Aine, Cholamuri, Ramkumari Marshari. How it is settled? Chart ko, within the Rayati Dokoni Shakto Vishito. This is how I got it.
4 নম্বর ধারা মতে
Rayati should Dokoni Shakto. That is the Rayat, I got the Ramkumari is the Rayat minor. Now,
where are you reading that? Where, which side?
Chart command, this is right hand side. Chart ko vidhimote Rayati Dokoni Shakto Vishito. At number vidhimote Rayati Dokoni Shakto Vishito. So I'm a riot. My this is the riot. And it is the several plots. And also the plot of 823. 823 is the whole of.
Your riot under section 4A of each act. Yes.
Under Middle Tennessee Act, here is the CS records. There is no civil legal. Under the 53 Act, section 4 notification was given.
Let us find out that under section 4A record of rights are prepared.
No, record of rights.
Under 44. I have never seen a record of rights being prepared under the 53 Act under section 4.
No, the 53 Act. Charco, before the Rayati Dokoni. 4 is given the, this is my status, man. I am a riot.
So show me from this document that this has been prepared under the 53 Act, finally published record of rights.
The document is very.
It is this may be pre-53.
No, 50 then Bharat Samra will be there.
I do not know.
But in the CS code, and here the CS code, that will be in the name of Bharat Samra.
CS is which year?
CS in 1930.
RS is which year?
After 53.
Find out the divisional. It is also pre-independence.
No, RS cannot be independent.
After the Estate Acquisition Act came into force, initially everything did not vest. Hard bazars did not vest. It vests much later. Did not vest. It vested much later. Yes.
Section 4 notification was given.
Yes.
Then my lord 5 says that hard bazar is also the rights, those are vested to the state government.
It did not, because it goes through the judgments. It did not at that stage. It vested much later.
Then 6 come. 6 has given the right to detain the lands.
Yes.
And 6A, B, C, and my 6C that redemption group.
6C, forget 6C resumption. You have right to retain certain lands, agricultural lands, non-agricultural. No.
My name.
So where is the finally published record of rights?
Rights. They are not disputing this. When you come to this is RS record of rights, then I have written the record of rights also.
And the next page is a suspect document completely. Absolutely.
Because just 30.
Look at the writing. Where is that original? Show me the originals. Bring it. Yes, bring it on Monday. I want to see the originals.
But Tuesday, my lord, I will seek instructions even.
Yes, Tuesday. Wednesday.
Wait, get from me.
List on Wednesday.
2 brothers.
Wednesday. Bring the documents. ফেরত দিয়ে দাও। Heard Mr. Rai, learned advocate representing the petitioners. Petitioner, one petitioner. Petitioners. List this matter for further consideration on বৃহস্পতিবার প্রোগ্রাম তাহলে হবে না Thursday. Wednesday, because it is not possible, there are other matters. Your matter will be there last, so after 3:30, it will not be what? In the morning, if it is taken up, it will be, you will be in a better position, Thursday. Very well, both 32 টা শুধু list 32 শুধু list on Thursday. I have not heard today, 32. This matter I have heard, so I have recorded that I have heard you. 32 I have not heard, 32 list on Thursday. Yes.
Hard work, trying to hard. But I have no matters. That is very great. You point ahead.
That is a different issue. Nobody knows what will happen. Nobody knows what will happen. I also do not know what will happen.
Yes, I also know. So.
Element of surprise is always there.
Nobody knows.
So the next matter. Yes, item number 33, who is appearing?
I am appearing, Milord, 33, Milord, the show cause notice under section 73 is under challenge on the ground of limitation. Now, Milord, my plea is that I didn't prefer an appeal. I came before this court directly because according to me, show cause is barred by limitation. 17-18 financial year. Subsequently, the government.
Power to extend is there.
It was extended under 161A. Now that provision specifically says extension only on the grounds of force majeure. But the notification does not disclose any force majeure, why it was extended. So this notification, extension notification itself came up for challenge before various high courts, ultra vires to the GST Act. I have also done that same year. Now the other high courts have admitted the writ petition. They have stayed all recovery proceedings pending adjudication. I am carrying those judgments. I am praying for similar interim reviews.
My lord, I'm saying, my lord, since ultra vires is challenged, my lord, the advocate general has to be served a notice, my lord, he has to appear, my lord.
Why did he
serve the additional advocate general?
No, the advocate general, principals.
I will.
And no interim order can be granted.
But other high courts have granted. I am carrying those judgments. Because the notification is prima facie bad. Milord kindly takes Milord.
First serve the advocate general.
Milord 168
having regard to the fact. Please challenge notification, ultra vires.
Notification.
What are you saying, sir?
But then I have to seek instruction whether the additional advocate general will be appearing. So I've just been allotted. I've seen the files is challenged. I have to take.
Why this is challenge of what?
The notification.
Notification.
Whatever is there under the sun, it should be served to the advocate general.
I've just been handed over the brief.
Monday.
Great.
Monday, only Monday.
Great.
Monday, one loss this week. Tomorrow, you are there tomorrow? Yes. Tomorrow, it tomorrow. Tomorrow.
33 Milord, service is not complete.
My lord, once again, I apologize, my lord. Since the additional advocate general might be appearing in this matter, he is from Jalpaiguri, he has vote tomorrow. Let it not be tomorrow.
You are there. I'll dispose it off.
Since notification is challenged.
No, unnecessarily. Notification has nothing to do with why this is.
I understand.
Tomorrow I'll take up your matter.
34 Milord, service is not complete. I have Mr. Bonik has not received the copy. 34, yes.
No copy has been taken out.
Wednesday.
No
Not
copy available, sir.
not possible for me to take up the matters like this. Isn't it? You have to understand.
এই 33 তো CGST ছিল। না 33 তুমি আছো? 33 ও আচ্ছা। and others আছে? and others নেই।
এই কালকে দিয়ে দাও। Tomorrow.
Tomorrow.
Round of limitation be there tomorrow.
I'm
Rejected on the ground of limitation.
Show me lot the cancellation order itself is bad.
No, I will not go into that. Your appeal has been rejected on the ground of limitation.
Ask them to consider.
What consider?
Blood, only my appeal. Blood, putting me outside the revenue blood won't help them.
Why have you rejected the appeal?
I do not know what is the issue.
Because the order, is the order of
Tomorrow is
cancellation.
the election in Siliguri.
Blood, page 15.
On the ground of limitation. Are sir, listen to me. I have already decided this issue yesterday.
Yes. Right. Mistress of judgment. The division bench judgment Millard has also relied in that judgment, which Millard has decided.
At least the read
You are there tomorrow?
No, tomorrow I may not be available.
You are not from Siliguri.
I am from Siliguri.
He is from Siliguri.
I am from Siliguri.
I am keeping it tomorrow. You see, these are the innocuous directions. Same direction.
But my lord, no read petition has been served.
Are you serve him now today?
I will do it.
No copy has been served.
What is the final order? I'll tell you.
Millard, the page
Same
23.
point, sir. This point is already covered by the division bench of Justice Boshak. Our High Court, I am bound.
Yes.
I cannot alter the situation.
That's true.
Justice Saraf's matter is different point.
Right.
You are aware.
Yes.
Justice Saraf's matter is different point. Justice Saraf's matter, you were in Allahabad, situation would have been different. Today you are in Calcutta. Two division benches have passed an order. So I have to follow that. And on that ground, I'll send it back to them. 15 days or 1 month. Say 1 month. In that matter, I made it 1 month. Because 15 days may not be practicable.
Yes.
So 1 month is better. I'll dispose it.
Kindly fix
But
it.
I will
Monday.
No.
Kindly fix it Monday after serving the copy.
So many matters are there. I serve the copy here and now.
Yes.
Tomorrow.
Mr. Bonik, learned advocate, enters appearance on behalf of the respondent number.
CGST department.
On behalf of the respondents.
I do not know the respondent number.
On behalf of the respondent number, on behalf of the respondent, on behalf of the respondents.
All the respondents.
Full stop, he however pays for an accommodation to take appropriate instruction in the matter. In view thereof,
No copy has been served. It is
served.
I am serving, right.
In view thereof, let this matter stand adjourned and appear under the same hearing tomorrow.
tomorrow.
If you are not satisfied tomorrow, Mr. Bonik,
Tomorrow I will not be available.
if you are not there, it will not be taken up. If you are not there, it will not be taken up. I will dispose it of in your absence. Did I say that?
Yes.
But if you are there, same point, Mr. Bonik, same point.
Right.
You consider, I have already uploaded, or you ordered to upload it.
In that case, kindly fix it Monday. Monday I can.
It will be uploaded today. Go through the order. Identical order I will be passed in this matter. You can, but you can check.
Yesterday's order.
Yes,
Already uploaded.
it will be uploaded and made some corrections. 1 month, Mr. Bonik, 1 month time I provided. 15 days was indicated,
Yes.
not practicable.
Not practicable.
1 month is reasonable. Or you want it more?
After going through the read petition,
Not this matter. The other matter, I've indicated 15 days. But later, while correcting that, I thought 15 days time to
15 days is very minimum.
Yeah, I thought. So if you want
Very
it, I can extend it for a little more.
1 month.
1 month or 2 months, whatever you want, I'll provide for that.
Okay.
1 month will be fair enough.
2 months is
2 months, I'll provide. Kindly tell the petitioner I have changed it to 2 months. In that matter.
But tomorrow I will not be available.
But if you are not there, it will not be decided.
All right.
এটাকে নিয়ে না জিএসটি ম্যাটার করে আলাদা করে উপরে একটা সময় দেবে মানডে করে দেবে জিএসটি এগুলো সব জিএসটি ম্যাটার করবে এইটাকে জিএসটি করে দিয়ে দেবে একটা আলাদা আমি এটা ডিসপ্লে করতে টপি দিয়ে দেবে একের উপরে হ্যাঁ ফার্স্টিং Yes, call the next matter.
But the hearing matters, the 3 analogous matters.
Yes, continue. Who's stopping you?
But it does not.
You don't want to do it.
No, I am more than eager to do it. But if I don't do it in this circuit, I don't know when it will happen. That's why
I do not know. But I will not permit you to say that the court does not reach the hearing matters.
No, I won't say that, but
You do say.
I said that, but it is not that it has not been listed, but somehow.
Yes, file up. Tomorrow you are there.
Yes.
DSGI will be there.
It's from Sri, I doubt.
Because this matter, whichever way it goes, I want to complete it. I've heard it. লাগবে এটা কিন্তু শেষ করার সময় পাচ্ছি না তো আজ 4টে তো বাকি পেন ফিক্স করে দেবো এটাকে সামনের সপ্তাহে না সোমবার দিন 3:30 ফিক্স করে দেবো আমি জানি না ওইটা নয় ওটা নয় একটা পয়েন্ট আছে ওই পয়েন্টে ডিসাইডেড নয় করে দেবো এটা কিন্তু মামলা ডিসাইড হয়ে এমসিতে আগে ওটা লাগবে না ওটা তোর কাছে আছে এটা একটু অন্য পয়েন্ট স্লাইড এটা লাভ নিয়মটা লাগবে
পেন্ডিং আছে in Krishnaram case first item
yes it's there
My lord, I came to know yesterday night that petitioner Krishnaram has preferred a revision before the statutory authority and is pending.
I'll direct you to dispose it of in Krishna. So far as Krishna is concerned. The other matters?
My lord, allow me to file a list of dates and short notes of argument by.
Let him complete.
Same matter, my lord.
Let him conclude. I will dispose of these matters.
He was arguing on Krishnaram.
yes
Krishna is the revision is pending. The revision is pending in Krishna.
I have no instruction. I don't know, my lord, whether revision is pending.
No, we have the copy.
Where is the revision? Who has filed the revision?
Krishnaram himself before the rail board. It is not annexed, my lord.
10th February 2024
That is after during pendency of this application. He has filed it. Matter is pending before that. Matter is pending from 2021. So I will not consider that.
So what happens to the revision?
It's up to you to take a decision in this. Matter is pending.
Reject
Matter is pending.
10 February 2024 ফাইল করে
No, my lord, then.
This is not a subsequent event. You see, Mr. Mujumdar, the writ application was filed in the year 2021.
Yes, ma'am.
If subsequently a subsequent event is there, which is he has challenged, he has filed a divisional application, but here the substantive challenge is there. More substantive challenge.
Same thing is challenging in two places.
So that whether you will proceed with that or not is different. Yes, continue.
Yes, now, my lord, the first point which we had raised was, my lord, that the order of the inquiry officer, the findings of the inquiry officer.
I wanted to ascertain from you, Mr. Mujumdar, yesterday, was the order report of the inquiry officer served on him?
Yes.
One. Where is the service of the report of the inquiry officer?
Lordship, he was given the inquiry report. He responded to it.
When is that?
My lord. It took that.
You see, there is one inquiry report dated 14th February 2019. You see that the same was served on him.
My lord, and let me take up the. My lord, if my lord is kind enough to take up the writ application itself.
Yes, page 39. Come to page
My
39.
lord, may I take your point?
Yes.
My lord, kindly takes page 24, the chart sheet. There is a
I've seen the
memorandum.
chart sheet.
Memorandum. This is not the final one, my lord. This is an indication given to the petitioner that an inquiry will be conducted on these lines. This is dated 26th April 2018.
26th.
April.
What is this according to you?
This is an memorandum, you will, my lord will see, this is the headed memorandum. It was an indication given to the petitioner that the inquiry will be done against you.
Let
on
us
these
understand
lines.
from the heading of this whether it is such or not.
Yes, my
Under
lord.
section 9 I of the RPF Act, read with rule 153.
Yes,
Come
my
to 153.
Yes, my lord.
Yes, what is 153? Procedure for imposing major penalty.
Yes, my lord.
So it is a charge sheet within the meaning of 153.
My lord, please wait a second.
Yes.
My lord comes to without prejudice to the provisions of the Public Servants Enquiries Act. Has your lordship got it? 153. No order of dismissal, removal, or compulsory retirement or reduction in rank shall be passed on any enrolled member of the force, save as mentioned in Rule 161, without holding an inquiry. So under 53 tells me to do an inquiry.
So this is the inquiry.
So this is the inquiry. That is why I'm telling your lordship that this was an indication given to the petitioner who was put on alert that the inquiry will be done against you on these lines.
So according to you, this charge sheet is
My
not.
lord, it is memorandum, my lord. It is not a charge sheet. Though, my lord, though it is headed charge sheet, my lord finds memorandum beneath it. And it is under 153 and sufficient caution given to the petitioner that you might be facing an inquiry on these lines.
26 the charge sheet.
Mr. Ghosh, please let me continue. Or should I seek protection of the court?
RPF দেখো
CIS would take no.
So according to you, this is a show cause.
Yes, ma'am. No, not show cause.
What is this?
It is a memorandum intimating. My lord may treat it as a show cause.
No. You tell me what I should.
No, my lord, it is not a show cause.
What is this?
This is an intimation given to him, a memorandum handed down to him that you be prepared an inquiry is going to be held against you on these terms and conditions.
Kindly come to paragraph 1.
My lord, Sri Krishna Ram is hereby informed that it is proposed to hold an inquiry.
Yes.
So he is being informed that an inquiry will be done against you.
Come to annexure 2, Mr. Modi.
My lord, we have to spell out the charges against what we want to bring against him. Otherwise, what if
articles of charge is there, annexure 2.
My lord, I am taking that. My lord, kindly allows me some time so that I can explain it.
You cannot argue something on the tangent that this is not a charge sheet.
My lord, it is not a charge sheet. It cannot be a charge sheet.
I'll record that. Very well. Very well. Thereafter.
Now, my lord, kindly see. Thereafter, the petitioner has responded from page number 30 onwards.
Yes.
This is dated 24/10/2018.
Yes.
My lord, here was cross-examination, whatever here was given, all these things.
Please wait.
I'm sorry.
My lord, then this inquiry was over on 28/12/2018. My lord, files on page 48. So 30 onwards, my lord, the petitioner responded to the inquiry.
Yes, thereafter.
My lord, then after that, before he was finally called up to face, on 14th February 2019, another 15 days was given to him by the disciplinary authority to respond if he has got further representation to be made.
To what?
Whatever allegations was leveled.
Sorry, please read the letter, sir.
My lord, please.
A copy of finding consisting of 7 pages is enclosed herewith with an instruction to submit representation, if any, on the findings of inquiry
Please read
report.
the subject.
Findings of inquiry report of CT/Krishnaram of decoy 4BL submitted by EO come post CC of whatever it is, my lord.
Yes.
So inquiry officer had submitted his report.
Right.
Against that, he was given another chance to file his representation.
Correct.
My lord, I am here to show to the honorable court that there is no procedural lapse. But I need not tell this honorable court that in a writ court, we should not look into evidence or findings, whatever. If the procedure is okay, we are okay. Now, my lord, thereafter,
let us see the findings of the inquiry officer. Final findings.
my lord, there is one catch in this matter. Now, my lord, the disciplinary authority has a power. If he is satisfied with the inquiry report, he may accept it or he may remit it back for further clarification.
Yes.
In this case, it was done.
Where is that document?
My lord, it was done on 9/2/2019. The document is annexed, my lord. It is page number 50 is the inquiry report. Lordship kindly takes from page 62.
Yes.
Certain clarification was sought for by the DA, inquiry officer made it.
Where is that order?
Order, my lord, it is not annexed. If your lord permits me, I will disclose.
Permit you to produce the records.
My lord, the order was.
But they filed their opposition, nothing is there.
No, no,
No, my lord, unfortunately, the position was prepared by another advocate. Nothing is there.
maybe produce records, whatever you want.
My lord.
Show me. I have not stopped you. Whatever you want.
No, my lord, I missed out that. I was
Doesn't
supposed
matter.
No, I was supposed to seek your lordship leave to produce the documents.
Produce it. I'm ready.
Lordship will produce it.
No, we not will. Final hearing, I'm hearing is
No, my
good.
lord, I cannot right now produce it.
Then it is all right. Not there, not there. Very well.
But my lord,
What is your answer on the basis of affidavit? What is your answer? Why was the second inquiry conducted?
Second inquiry?
Yes. Page number 62.
Page number 62. It was not on second inquiry, lordship. That is what I'm showing you. The DA has the authority to remit back for
Correct. Show me that order.
My lord, allows me to file that order.
No, that if the opposition has already been filed.
Yes, my lord.
Now, if you have not produced that order today also, then nothing more than that.
My lord, actually, I missed out. I was on the very starting. I was supposed to seek your lordship leave to file that document.
No, what is the opposition say? Let us understand what is the opposition say. You said it's a preliminary inquiry.
Yes, my lord.
Language is different. What you are trying to submit. You say this is a preliminary inquiry.
This is a fact-finding exercise.
Very well.
প্রিলিমিনারি ইনকোয়ারি R1 এ আমাদের দেওয়া আছে। এটা হলো প্রিলিমিনারি ইনকোয়ারি, যেটা বললো হলো তোমার এই অফিসার কল্যাণ বেরোয়। তারপরে অ্যাপয়েন্ট হলো তারপরে অরুণ রায়
And my lord,
ইনকোয়ারি অফিসার, সেটা চেঞ্জ হলো রাকেশ কুমার।
One thing, my lord, may be kind of wrote. Mr. Kollan Deri was appointed as the inquiry officer.
Yes.
Upon the protest made by the petitioners, he was changed and another inquiry officer was appointed.
Yes. Yes.
So there is a report by Mr. Kollan Deri and a report by Mr. Ashish Rai, Arun Rai.
Annexure P6 is by whom?
Annexure P6. Is the petitioner?
Yes, see.
inquiry officer. Second inquiry officer. The inquiry.
And the first one by?
For at page
both are kissing. Both are kissing.
No, both are kissing.
Both are kissing.
So therefore,
Both are kissing.
so therefore, it is not the case that second inquiry was by someone else.
No, my lord,
there has to be order.
Let me explain. If I file a report and if your lordship wants clarification on the report, can Mr. Singhania clarify my report?
Where is the order asking for clarification?
I am asking your lordship to grant me that leave to produce the document.
No leave is necessary. You could have brought it on record. No special leave is necessary, Mr. Mojumdar.
My lord, since I have filed my opposition, I need the court's permission.
Yes. Thereafter, any other point on this?
No, hold on. It is not an inquiry, it's clarification. Now, my lord, that is also permitted by the rules. To ask
Show
for-
me rules. Show me the rules which permits you to hold repeated inquiries.
My lord, it's again hammering the word repeated inquiries. I am-
Absolutely. As long as I do not get an order from you saying that the first inquiry has been set aside by the
My lord, I
inquiry,
never said the first inquiry was set aside.
then what has been done to that?
There was certain the first inquiry did not give a clear finding, so the DA said give a clear finding.
Where is the provision in the
Achha,
rules
that
which authorizes that?
Yes, my lord.
Yes.
154.4.
That's 154.4.
Yes.
The disciplinary authority, if it is not itself the inquiring officer, may for the reasons to be recorded, remit the case to the inquiry officer.
Where is the recording? That is why I want to know where is the order.
My lord, again, I am saying, allow me to file the document.
No, you want to file it, you file it. If you do not file it, it's gone.
Then, my lord, allow me to file a short notes after the
No,
argument is over.
The matter is being hard.
After the argument is over.
Yesterday, I clarified the situation to you. Bring it to me. The matter was heard yesterday. You did not. Your officers are not cooperating with you.
वो दूसरा किस पे दिखाइए था?
The records are with you.
No, my lord, not Krishna Rams. I have that document of a difference of the.
Find it.
I'll right now show you.
Yes. Let me find out what is there. For reasons to be recorded in writing, what are the reasons? I want to know.
Look, if there is a disagreement, 154.5 comes into.
Disagreement is, let us understand. Let us understand what is there. You know what is there. Have you seen that paper?
No.
Then you have suppressed it.
And that I have specifically stated in my pleadings, that when the second inquiry was conducted, why it was conducted, nothing was served upon me. That's specifically stated.
Nothing was served upon you.
Yes.
So that is not required to serve upon you.
No. I've
Has to
stated
be.
in my pleadings that nothing has
to
been
be.
served.
My lord, an inquiry is, nothing is changing, only certain clarification will asked by the DA to the inquiry officer.
Let us see whether what is there. I do not know what is there. Which paragraph you have stated that?
Yes. Para 22.
How is it dealt with in the opposition?
Nothing. 22 and 23. Your petition 23, I'm reading out, that the said respondent must say inquiry officer again held a fresh de novo inquiry proceedings in terms of the said direction of the disciplinary authority, although no copy of the said order of the disciplinary authority was supplied to the petitioner and submitted his purported findings.
Paragraph 22 of your writ petition, you have raised this point.
What is it?
I do not know, my lord, your petitioner says that from the said purported findings.
Difficulty is when you are appearing for the authorities, it is difficult to at times come up and argue a matter because you see most of the time you do not get assistance from the officers. Let me understand the situation.
Nothing, it is here, my lord.
Yes. Show me that. You read it for me. You read it.
My lord, it is dated 26 January 2019.
Yes.
Findings of inquiry report of Ghanshyam, the other case. The inquiry report by so in reference to the above and on perusal of the case file and findings of the inquiry report of CT Ghanshyam Das Meena of A. Koi, the BN for NGP has for CO BN has passed the following remarks on carefully gone through the.
Who has passed?
Assistant Commandant. That on. Assistant Commandant. Commanding officer on carefully gone through the case file and found that the party charged was given every reasonable opportunity to defend his case. The findings submitted by the EO are not conclusive whether the party is charged guilty or not guilty.
Let us find out. From the.
Hence, as per rule 154(4) of RPF rules 1987, the case is remitted back to the EU for further inquiry and report.
Let us understand from the report whether it-
161.
161.
The conclusion of the first inquiry report.
Where is that?
161.
161 page.
Yes, page, sorry, minute 60. Oh, 60.
Same. I hope, Mr. Mojumdar, this will be same for all three.
Hopefully.
Oh, yeah. You bring it on Monday, that document. That's considered.
Document I have shown, my lord.
This is in the other matter. Krishna's matter, you bring it on Monday.
Now 61, Millard, is a
My lord,
clear finding.
My lord,
Yes.
my lord, Krishna Ram's file is now with the railroad.
I do not know. That is
And the
exactly
revision.
up to you. Matter is high before the High Court, pending before the High Court. If you have sent it before the railroad, it is for you. Matter is pending with the High Court. I'm hearing the matter.
My lord, it is not when the matter was taken up for hearing, when the matter was.
No, that I do not know, sir.
So fine, my lord.
So 61, the first inquiry report. Hence, being the inquiry officer, after taking the statements of the PWS and documents produced into consideration and after impenetrably perusal, the charge brought against charged force member Krishnaram found to be doubtful. Charge found to be doubtful. After completion of the inquiry, the force member appears to be guilty.
Lordship, I.
Positive conclusion.
No, my lord. This is the first report. So it is my humble request to the court, my lord, clarification to be sought by the petitioner or from the respondent. Not at the same time at the.
Let me see that. একবার দাও তো এটা তুলে এই বর্মন ঘুমোচ্ছ কেন দাও না কি করো ঘুমোচ্ছ
That is why this, if the charge is doubtful.
fine. If you can open that letter or together action madam.
If the charge is doubtful, my lord, I cannot pronounce him guilty. So that is why the DA said you say whether he is guilty or not guilty.
Not really. I find that he has been specifically held to be guilty.
Where, my lord?
Page 61.
After he said charge is doubtful, held.
Maybe he's held guilty. He's held guilty. So he could have disagreed with the findings.
He disagreed.
He said it is not clear, not conclusive, whether the party charged is guilty or not guilty. And remitted back to the inquiry officer for further inquiry and report.
My lord, we are hinging on the discretion of the commanding officer.
He has no discretion in the matter.
How he will conduct him in writing a letter to his subordinate.
He has to conform to the provisions of law.
154(5) once, Millard. He has to record reasons for such disagreement and record its own findings on such charge.
One 154(5).
154(4) and 5, both are relevant.
No, action. You are on
Yes.
action.
Yes, 154(4) and 5.
এই 2 নম্বর ফাইলটা দেখি 2 নম্বর ফাইলটা দেখি পরেরটা নেক্সট ম্যাটার ঘনশ্যাম দত্ত which page which page No, this is different matter.
Yes.
Here that second charge sheet is,
Second charge sheet is not there.
no, second inquiry report is not there.
No.
But in this case, the records reveal that he had directed further inquiry.
Yes, but that was not supplied to me. That is why, my lord, it could not be annexed. I was only served with the final order of punishment. I have admitted that there was a second inquiry at para 24. That was within my knowledge, but that copy of the inquiry report was not with me.
No, sir. If you are aware, you are aware. If you are aware, you are aware. Mr. Mojindar, kindly show me from this document that the second inquiry report, first inquiry report, what is the finding here in this case? Because these two facts are different. Krishna Rama's facts and these facts are different.
Not absolutely similar, little bit
Absolutely
different.
similar.
No, not absolutely similar, little bit difference is there.
Find out whether it's from the first inquiry report, what is the finding here in this case? Is there a first inquiry report? He has
Yes,
not.
my lord, there has to be one.
Find out.
Lordship, if you take some supplementary affidavit.
Okay, he has disclosed it.
R1. Ki? Kalyan Dev.
R1 supplementary reply.
A1.
R1.
R1 is your, it will be opposition. Affidavit will not.
Supplementary opposition against supplementary evidence.
This is not there, my lord.
Checking up.
I'll find it out.
Affidavit in opposition to this yes, I've got it.
Report.
Yes. Conclusion, if he is found guilty. He is found guilty.
Yes, my lord.
Then why the second inquiry? Because he was not happy with the inquiry. His satisfaction must be recorded. Satisfaction, as you have disclosed, does not fit in with the document. His satisfaction may be anything. Maybe anything. He may have recorded so many things. But what he has recorded does not fit in with this. Your junior has rightly pointed out. This matter, this decision was already taken up. He was held guilty. Then what was the necessity to remand the matter? To cover up the lacuna already held. An inquiry is concluded. Lacunas are indicated in the inquiry report. In response to the inquiry report. A further inquiry is called for. Reasons provided are different, and at least it appears from the inquiry report that the reasons for which the inquiry was directed to be held could not have been the reasons for which the same was held. Page 20 of the supplementary affidavit, as is pointed out. Krishna, if he goes, Krishna is different. Krishna is a little different, but this matter is absolutely on this point.
So Krishna also, if you takes the two inquiry reports, in the second inquiry report, the conclusion part is lengthier. More inputs have been supplied. However, The basis has been said only to be a Facebook screenshot. So on merits, the conclusion appears to be not.
Now, what
with
prejudice have you served by this? Next point. Assuming this is correct,
Yes.
what prejudice have you served? Then
So
the next point.
They improved upon their reasoning. Something which was not there in the first inquiry report could not.
But
be
on the basis of
granted.
an inquiry, what prejudice did you suffer on account of the inquiry?
As such, I cannot say I have suffered any prejudice
Then-
because when the final order was passed, the final order imposing punishment was passed on a reason which was neither there in the charge sheet nor in the inquiry report. Because the final punishment has been imposed on the ground of suppression of information.
Which is not there.
That
in
was not there in the charge sheet. That charge was never leveled against me. If Miller takes page 102, the disciplinary authority holds me guilty of suppressing facts/information. That is from their records, which was never there in the charge sheet. And the
In
punishment.
this case also,
Yes, same. And the consequent punishment is stoppage of next annual increment.
That is
for a
different.
period.
That
It's
neither
a
here
minor
nor
penalty.
neither
Now,
here nor.
well, I am saying this because subsequently, when the appellate authority, being the DIG, he enhances the punishment to dismissal of service. On what basis that could have been done? That also becomes perverse.
Why?
Because a punishment which itself was initially perverse, without adequate reasoning on a charge which was never in the charge sheet, can that punishment be subsequently enhanced?
Come to the show cause,
Yes.
page 105. It says charges approved.
Yes.
So it ignores the order.
Ignores the order. Charges are proved.
So your prejudice point goes, your point also goes that it was based on an order which was, it was based on, the order of punishment was based on charges which did not form part of the charge sheet. It also goes.
Now, which charges have been
Let us
proved?
find out what the appellate authority has finally passed.
Yes, now which charge has been proved?
Let us see.
Yes.
Charge which is there can only be proved. That is no settled law.
Now, Miller takes the supplementary affidavit because the final order of
Is not there.
So by supplementary affidavit.
Yes.
Supplementary
23rd
June, page 10.
Yes.
Second paragraph. Enquiry officer conducted the enquiry and submitted enquiry report with its findings holding the party charged guilty of the charges leveled against him. But disciplinary authority, while awarding the punishment, took lenient view and awarded him the punishment of stoppage of so and so. Next, since the charges were very serious and grave in nature and also well proved during the course of inquiry, but punishment imposed by the disciplinary inquiry was not commensurate with the gravity of the proof charges as such, as show cause notice in terms of 219 was issued to him by the then reviewing authority as to why punishment should not be enhanced. Now, let I stop here for a moment.
No, you continue. Why you stop?
Because from this paragraph, it is therefore evident that the appellate authority, this officer proceeded on the basis of the charges according to him, which was proved by the inquiry officer, not the charges on the basis of which the disciplinary authority found me guilty.
Correct.
That's purpose. If this is not, he is enhancing me the punishment of charges which were according to him proved by the inquiry officer. Proved by the inquiry officer. Now, subsequently, I am awarded a punishment on basis of different charges.
Show
now
me that.
Yes, page 100 of the writ petition, suppression of information.
That is the disciplinary authority.
Yes.
Now the appellate authority.
So the punishment.
Says,
so the punishment is.
Appellate authority says that the charges have been proved. Charges as per the inquiry report have been proved.
Yes.
It says that the punishment inflicted on you does not commensurate.
But the punishment is for suppression of information.
That is different. But why has he imposed the
Yes,
punishment?
the no reasoning. Next paragraph. Instead of relying to the show cause notice, appellant filed a writ petition number so and so in the Honorable High Court of Calcutta against the impugned order of punishment imposed by D and against the show cause notice dated so and so. The same writ petition was disposed of by the Honorable High Court Calcutta with direction to the respondent to consider the prayer of the petitioner dated so and so for preferring appeal. In accordance with law, within a period of 4 weeks from the date of communication of the order and communicate the same to the petitioner within a week therefore. In compliance to the court's order dated so and so, a 30-day more time was granted to the appellant on ATO for preferring an appeal. In this regard, appellant submitted his appeal on 17th October 2019. On carefully going through the contents of the appeal and records available on DAR case file, it was found that all the above charges are proved on the basis of statements of PWs and documentary evidence. But the punishment awarded by the disciplinary authority was found to be too lenient and not commensurate with the gravity of the offense. As such, a show cause notice, the first show cause notice, 10th June 2020, writ petition of filed, the para 11, the third paragraph. I have carefully gone through the contents of the appeal and record available on the file. It is evident from the record that the appellant post a provocative message on social media that is, "Bahut acha kiya bhai ne," in support of brutal act of murder against accused so and so. Justifying such an act and instigating other members through Facebook can never be acceptable. Even an ordinary citizen could not condemn such a heinous crime when as the appellant, being a member of the armed force, supported a brutal act of murder of its superior officer on social media. In view of the above discussion, it is observed that the inquiry was conducted as per procedure laid down in Rule 153 of the RPF.
1 minute. Let us come back to the charge sheet once.
Yes.
Now let us see from the charge sheet.
Yes.
Come to the appendix, annexure 2.
Yes.
Of the charge sheet. The charges.
Article of charges.
Yes.
Is charged for serious breach of discipline, violation of lawful orders, and discreditable conduct prejudicial to the discipline of the force. In that, Sri so-and-so and undesirable comments in the social media in Facebook, pertaining of passing of objectionable and illegal comments on the Facebook social media in connection with the post-killing period of Sri MC Tagi, the report reveals that so-and-so did initial post on Facebook, Tiger conversation upload and video clip at 6:21 hours on the day of assassinate in and the like most derogatory comments against the deceased DC. Therefore, contravened so-and-so of RPF rules and committed the offense of rule so-and-so of RPF rules. Now, Milord, kindly comes to page 77 once. The
Yes.
conclusion of the inquiry officer. If someone proceeds on the basis that the charges have been proved, that prima facie must appear to have been proved. I am not going into the quality of evidence. I am going on the basic criteria that if I pronounce that it has been proved, preponderance of probability, naturally, which is the standard of evidence here, at least some sort of materials on the basis of which one can say, yes, there was a preponderance of probability. Now, Millard, kindly take 77 once. I'll straight away, Millard, the finding starts, come to the middle portion.
Yes.
However, during the entire investigation, screenshot of Facebook only is available as original record, which is the basis also the charge. During entire investigation, the said member of the force did not agree that the Facebook account was his account and the comment which was passed by him.
Which page?
Page 77.
Yes. This is the second inquiry.
This is the second inquiry.
Yes, rely on the second inquiry.
Yes, I am relying on that.
Yes.
Because by that time
Because
they have-
right, wrong, indifferent, whatever, there is an order passed by the commandant.
Yes. Yes.
Yes.
During the, I am reading from the middle. However, during the entire investigation, screenshot of the Facebook only is available as original record, which is the basis also the charge. During the entire investigation, the said member of the force did not agree that the Facebook account was his account and the comment which was passed by him. However, when he was asked that the documents available from the department which contains the particulars of the comment, how the photo and address name resembling that of him, how comment was passed to the said account, then the member of the force admitted that it is not possible for him to give the particulars as to where his photos and other information have been given and how these have been used. So it is proved. Now let's see how they are treating it to be proved. So it is proved from this that the said member of the force does not deny the hacking of his account. After the incident, when the said comment was passed and in preliminary inquiry, when the said member of the force came to know that comment has been passed from the Facebook account resembling his name, photo and address, then neither the charge-sheeted member of the force lodged FIR with the police nor considered it
Can
necessary.
be said that it is not based on any evidence.
Milord?
Not based on any evidence.
No, what is the evidence? Facebook screenshot. Who produced that? That there was no presenting officer. There's only one officer. The inquiry officer acted as the presented officer. He put the questions. There are many fundamental flaws in the entire proceeding, that how it has been conducted. If incidents that either the charge-sheeted member has made the comment himself or his Facebook account was hacked, which was not informed to the police or to the department by the charge-sheeted member of the force, in both the circumstances, it is established that the charge-sheeted member is getting, if misleading the department, which is contrary to the conduct of members of the force. If it is normal that any accused denies, it is normal that any accused denies the charges leveled against him. The inquiry proceeding has been conducted by giving full opportunity of defense. During this charge-sheeted member of the force, Krishnaram cannot furnish any record, document and evidence lawful. Then the aforesaid member of the force is an armed member of the force who has violated the discipline and rules of the force. Well, if this is not kangaroo justice, then what kangaroo justice is then? I ask to myself. You are predetermined. It's a preconceived notion bias, which we call in administrative law. It's apparent from the face of the records. The conduct, how it has been done.
Yes, that is all.
That's all. That's all their finding is. On the basis of this, dismissal from service.
Tomorrow?
Tomorrow I will not be coming.
Yes, means tomorrow means effective.
Monday. My lord, for Monday, may I make one request?
Oh, yes, or I'll permit you to produce records.
No, my lord, not only records. My lord, when my lord allows me to argue, please restrain Mr. Ghosh from interjecting.
Monday, when you want it, tell me, I'll fix a time.
No, your lordship, as your lordship.
Milord, if I may suggest, Milord, 3 PM would be Milord.
Boston malo thaklo.
3.
My lord, then should I file the document by way of affidavit or just a list of
Give
documents?
me, I'll take it up. Records I'll entertain, whatever document you want
No,
to
my
rely.
lord, should it come under a list for the convenience of the court?
Only one document you want to rely, that decision, nothing more. Otherwise, list is not found. You want to rely on that document, I will permit you.
Lordship.
Or the learned advocates appearing for the, or the learned advocates appearing for the parties list this matter for further consideration on Monday, mark 3 PM.
And Milord, I would just crave leave to Milord to start with Milord 15 minutes, only to place 2-3 judges. Thereafter, Mr. Majumdar can sit.
Monday at 3 p.m.
Great.
My lord, then I will be starting on Tuesday.
Very good.
Given to Mr. Ghosh 15 minutes.
Yes.
Great for me.
Yes.
কাগজ গুলা নিয়ে